Okay, Chair Nylander, when you're ready, we can get started.
Very good. Good morning, everyone. I would note for the record that Chair Douglas was unable to attend today, so I'll be glad to sit in as chair as he requested. Today is December 14th. It is now 9:04 a.m. This is our regularly scheduled December Cannabis Control Board hearing. Why don't we begin with the call to order, the roll call?
Great, thank you. Member Merritt.
Present.
Member Young.
Present.
Member Durrett.
Present.
And Chair Nylander.
Present. And the record should reflect that all members are present and are able to hear and communicate via Zoom. Apologies accepted from Chair Douglas, who couldn't be here. So if you could reflect that for the minutes. Let's begin with public comment.
Great, thank you. So we'll start here in Las Vegas. Is there anyone here wishing to provide public comment? If you could come up and just please provide your name, and you may begin.
Hi, Chair Nylander, Director Cannabis Board. Thank you. My name is Jim Lewis. I'm an attorney with the City of Las Vegas. We do come from time to time to show our appreciation to you, your staff, the board. We like to let you know we're still interested in what's going on, and we will be at the workshop later on the lounges and looking forward to that. Thanks very much.
Great, Mr. Lewis. Thank you for your comments.
Is
Additional
there anyone
comments?
else? Oh, excuse me.
Good morning. My name is Frank Hawkins, and I rise to speak to item number 7 on the agenda. I'm opposed to the proposed regulations in its current form. Regulation 1, issuance of regulation, construction and definitions, diversity applicant, and diversity certifying entity. Also B, regulation NCRR 4035 for violations of both 1 and 2, and item C, regulation 5 for certification as required to qualify as a diverse applicant. I'm opposed to the proposed reasons. Nevada Wellness Center is 100% Black owned by 3 Black males. 100% of the Black owned marijuana, the only Black owned 100% marijuana dispensary in the state. I see this as creating barriers, especially as it relates to the category 1 and 2, where category 5, if they're purposely doing a violation, would seem to me to be the appropriate penalty that you would be issuing. I did review, and I don't see any African-American or Black agencies that will be doing any certifying. That's a why not question. I, Frank Hawkins, Andre Rhodes, Luther Mack Jr., collectively Nevada Wellness Center, are requesting a waiver or an exemption from these Cannabis Compliance Board regulations if you so far move forward and approve them. The CCB has a responsibility per the state of Nevada legislature to figure this out, not to advocate its issues to third-party agencies. This will cost African Americans and other minorities more money. Has the CCB studied the diversity issues, which has created barriers to entry, with Nevada Wellness Center being the only 100% Black-owned dispensary in the state of Nevada? If the CCB approves the proposed regulations, you will be treating Nevada Wellness Center and its 3 Black owners differently than anyone else. Did CCB collectively review information from prior dispensary application rounds and share that with us, the public? Did CCB review historic failures and successes that Department of Transportation, City of Las Vegas Minority Business Program, Clark County, Department of Aviation, Las Vegas Valley Water District, several minority business studies that have been done over the state in the last 30 years? Please don't make a decision before studying the issues and sharing them with the public. No one from the CCB has asked our opinions about any of this, not that you have to. But by passing this regulation, you support adding barriers that hinder Black applicants and stop most of them before they start, while the white male has no such issues. As the CCB staff researched current barriers from the prior two applications, 15, 14, and 18, educational requirements, money requirements over the $250,000 limit, marijuana experience, mandated pre-bid hearings to address questions publicly, releasing the scoring process to the public so everyone is on the same page prior to the applications being released. Your decision today negatively intended consequences for many decades to come, if so. Your decision could be more important than the consequences that may suffer. Our question to the Cannabis Compliance Board is it lawful to make a decision without all the information? Your positive decision will give birth to negative consequences that we all will have to live with. Please don't be irresponsible, get all the information. In closing, you say a diversity applicant means an applicant who wishes to have diversity considered as a criteria of merit. You say diversity certifying entity means an entity approved by the board to certify an applicant. I say your definition of diversity means dilute Black people. We shall see how many Black applicants there are and how many receive dispensary and or consumption and or social lounges, licenses for in these future application rounds. This game of chance we're all playing in Nevada is just a game that benefits the wealthy. The game of chance should be the opportunity for all Nevadans to participate in this billion-dollar industry. Thank you very much.
Thank you for your comments, Mr. Hawkins. There's further public comment from Las Vegas.
Chair, I don't see any here.
Let's move to Carson City and see if there's any public comment there.
I see no public comment in Carson City.
Very good. We'll close the section on public comment. That brings us to the item 2, which is our meeting minutes. We have 4 sets of minutes, 2 emergency meetings. We had a workshop and a regular meeting. Have the board members had a chance to review the minutes? And if you have any comments, please state so now. Seeing none, I'll accept a motion on these 4 sets of minutes. I think we can take one motion, items 2A through D. Is
This
there a
is
motion?
Member Merritt. I move that we approve the minutes,
A
all
motion
4
on,
of them.
a motion on the floor to approve the minutes. Do we have a second?
This is Member Young. I will second that motion.
We have a second from Member Young. All those in favor, please signify by saying aye. Aye.
Aye.
Aye.
Aye.
Any opposed? Seeing none, let's go to item number 3. These are our settlement agreements. And let's take 3A first. Do we have a representative from the Attorney General's office?
Yes, Chair Nylander, I'll be presenting this. L. Christopher Rath, Senior Deputy Attorney General. Good morning, Chair Nylander and members of the board. We have 2 settlement
Excuse
agreements
me, please. Mr. Rath, this is the court reporter and you sound very far away to me.
Is this a little
I'm
better?
having trouble hearing you.
Is this better?
Yes, that is. Thank you very much.
Okay. As I said, Chair, we have 2 settlement agreements up for approval at this meeting under agenda item 3. As per usual, I'll provide you with a summary of each and the Attorney General's recommendation for approval of each. You may then ask me any questions, and counsel for one of the respondents is here, and the second respondent for the second agreement does not have counsel, but their managers are present. So I will proceed first with agenda item 3A, which involves the case of CCB versus FSWFL LLC, CCB case number 2021-39. The complaint in this case was filed and served on August 3, 2021. On September 7, 2021, respondent filed its answer, affirmative defenses, and request for a hearing. A hearing officer was signed and the parties proceeded with a disciplinary process. During the disciplinary process, the parties exchanged the relevant documents and at the same time conducted settlement negotiations. Eventually, the parties came to an agreement to resolve this case that was mutually agreeable to the respondent, CCB staff, and the Attorney General's office. The parties then agreed to a stay of the disciplinary process while CCB considered approval of the settlement agreement before you. The events at issue in this case occurred at FSWFL's cultivation and production facilities during September 2020. The allegations in the complaint include a failure to properly follow the state's seed-to-sale tracking system at both facilities, which included issues with tagging plants and product and storage of cannabis. The complaint also alleged that both facilities failed to properly dispose of cannabis waste as their waste logs did not contain all the required information. As set forth in the proposed settlement agreement to resolve this matter for the cultivation facility, respondent admitted to one category 3 violation for storing cannabis outside the seed-to-sale tracking system, and a second category 3 violation for failing to meet the requirements for disposal of cannabis waste. As to its production facility, respondent FSWFL admitted to one category 3 violation for failing to follow seed-to-sale tracking requirements, a second category 3 violation for improper storage of cannabis, and a third category 3 violation for failing to meet the requirements for disposal of cannabis waste. Respondent also agreed to pay civil penalties in the total amount of $150,000 with an option for paying this over time with a payment plan as detailed in the settlement agreement. Respondent also provided a plan of correction, which is summarized in paragraph 22 of the settlement agreement, and CCB staff has approved this plan. The plan of correction includes the following. Number one, respondent has implemented a new system for ensuring plants and products are properly tagged. 2, respondent tagged the fresh frozen bags of cannabis that had already been properly tracked in metric. 3, respondent voluntarily destroyed the cannabis product that could not be reconciled with metric. 4, respondent implemented a new protocol to update weights in metric as soon as the flower is dry. And 5, respondent updated its waste logs so that they are now compliant. Based on this, the Attorney General recommends and requests the CCB approve this settlement agreement. I'm available for any questions, as is Mr. Brian Hardy, who is representing the respondent for this matter.
Good morning, Mr. Hardy.
Good morning, members of the board. Appreciate your consideration of this settlement agreement. Appreciate the hard work and diligent work with the Attorney General's office. They've been, and the hearing officers that were engaged in this matter. We were able to reach a resolution, which we deem appropriate. The only thing I'll correct on the record is the plan of correction is actually identified in paragraph 23 and not paragraph 22. Beyond that, I'm happy to answer any questions that you have.
Great. Let's see if there's questions from the board of either Mr. Hardy or Mr. Rath at this time.
No questions.
Very good. Thank you, Mr. Hardy. I would note, well, I should ask you for the record, you've had a chance to review the settlement with your client and are in agreement with its terms.
I have, and my client and myself have both signed on the dotted line on the bottom of it, so we're ready to roll.
Okay. Very good. Then if there's no further questions, let's take a motion on item number 3A.
This is Member Young. I will move.
Record. Go ahead.
Go
Member
ahead.
Young.
Go ahead.
I move to approve item 3A, the settlement agreement between the CCB and FSWFL.
I have a motion from Member Durrett. Is there a second?
This is Member Young. I will second that.
A motion and a second. All those in favor signify by saying aye.
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 Any opposed? Motion carries. Let's take item 3B, Mr. Rath.
Thank you.
Thank you, Chair Nylander. Item 3B is for the case of CCB versus Urban Hills LLC, CCB case number 2021-39. 56. This case does not involve a complaint, as the parties reached an agreement to resolve the regulatory violations that the CCB staff found during the investigation of this licensee's transfer of interest request. Respondent agreed to waive the filing and service of a formal complaint as noted in the settlement agreement. As you will recall from our October meeting, this matter involved unauthorized transfers of interest and the late filings of tax reports. I would note that there were no late payments of taxes involved. Rather, it was simply for late tax reports, and those had zero returns. That was the issue. Per the board's direction, the principals of the licensee provided further documents to the CCB staff and had extensive additional discussions with CCB staff. After this process, CCB staff was satisfied that preventative measures had been undertaken to avoid similar issues in the future. CCB staff was amenable to resolving the regulatory violations found via the settlement agreement that's before you, and they then engaged the Attorney General's office to negotiate this resolution with respondent. As indicated in the settlement agreement, respondent waived its rights to the filing and service of a disciplinary complaint and admitted to the imposition of one Category 2 violation for unapproved transfer of interest and one Category 5 violation for failing to timely submit tax reports. Respondent also agreed to a civil penalty in the amount of $20,000 and a formal warning from CCB under the Category 5 violation. Payment would be due by February 1, 2022, if the board approves this agreement today. The settlement agreement also includes a summary of respondent's plan of correction, which CCB staff has approved. This includes the fact that they have hired a compliance officer who will monitor tax report deadlines and assist in dealing with transfers of interest. They've also retained new bookkeeping and accounting staff and updated and revised some standard operating procedures. CCB staff agrees that the admitted violations, the civil penalty, and the corrective action taken appropriately addresses their concerns, and that the licensee has been fully advised about and understands the gravity of its mistake. Additionally, if the settlement agreement is approved today, pursuant to paragraph 26 of the agreement, the pending TOI request would be deemed approved upon CCB's receipt of the civil penalty payment, which should then also take care of our first item under Agenda 4. For the foregoing reasons, Attorney General recommends and requests the CCB approve the settlement agreement. Dustin and Crystal Pebbles are here as the managers for the respondent company. If you have any questions for me or the Pebbles, we're available.
Good morning.
Morning. Thank you all for, we were here in October, and I appreciate you allowing us to circle back to staff and have necessary conversations to kind of get us all on the same level as far as questions that were needing to be answered. I believe we answered those questions, and I thank Mr. Staley and his staff, as well as Mr. Rath for, the discussions that we needed to have and resolve these issues. So I believe we're all wrapped up and in agreement.
And this is Chairman Nylander. I did have a question for you. I note that as part of the settlement, you've hired a compliance specialist. Is this individual from the outside, or was it an internal hire?
She was internal.
Okay. And she has necessary experience in compliance matters?
She's been with us for about 8 months to a year now, but she's been closely monitoring, following the changes that are happening within the CCB, and making sure we're staying on top of any updates and regulations.
Very good. I think that's a wise choice on the part of the company to have a person dedicated to those functions. I know coming from gaming world, that's a very common thing. And I think it's probably something we're going to see more of in the cannabis industry as well. Also should note that you settled this matter without counsel, and you're appearing without counsel today. But I want to make sure you acknowledge that you understand the terms and conditions of the settlement agreement and that you can abide by them.
I do, and we can, yes.
Great. Let's see if there's questions from the board for the licensee or Mr. Rath. Seeing none, I think we're prepared to try a motion on item 3B.
This is Member Young. I will move that we approve item 3B cannabis compliance versus Urban Hills.
I have a motion from Member Young. Is there a second?
This is Member Merritt. I second.
Second from Member Merritt. All those in favor signify by saying aye. Aye.
Aye.
Any opposed?
Aye.
Seeing none, the motion carries. But thank you for your time, Mr. Rath and the licensees. That brings us to item number 4, requests for transfers of interest. We have Mr. Staley today.
Yes, sir. Good morning, Mr. Chairman.
Morning.
Little bit of a flashback here. Chair Nylander, Member Merritt, Member Durrett, and Member Young. For the record, I am David Staley, Chief Investigator for the CCB. I'm here to present agenda item number 5, which consists of 6 transfer of interest or TOI applications. Item A is TOI application for Urban Hills LLC or Urban Hills. TOI number 17004 requests approval for internal transfers resulting in Dustin and Crystal Pebbles together 100% company. Staff identified areas of concern with this application regarding TOIs that had occurred without prior CC approval and late filed tax returns. The board has just approved a settlement agreement with Urban Hills during its prior agenda item, but staff had scheduled TOI 17004 as part of agenda item number 5 in an abundance of caution in case the board did not approve the settlement agreement. As a result, no action is needed on this item. I'm available for any questions, and with that, Chair Nylander, I'll turn this item back to you.
Thank you, Mr. Staley. I did not have any questions or concerns. This item really formalizes what we did on the previous item, and we've had these discussions with the applicants previously in October, I believe. So let's see if there's any questions from the board members for Mr. Staley. Seeing none, let me make sure the Pebbles, do you want to make an appearance at all on this, or are you comfortable?
As you stated, sir, I believe that it's kind of all laid out in the previous discussions, and pending our payment of this settlement agreement, we'll move forward with the TOI.
Great, thank you.
Thank you.
Questions from the board?
No.
Seeing none, let's take a motion on item 4A.
Chairman Nylander, this is Chief Staley. I believe that the board approved the TOI as part of the approval of the settlement agreement. I don't believe that board action is necessary. Correct.
Well, very good. Then I'll just refer that matter back to the staff at this time, and then we'll do a withdrawal on it later when we can agenda it properly. So let's go to item 4B.
Thank you, Mr. Chairman. Item B, this is David Staley, Chief Investigator for the CCB. Item B are the TOI applications for GB Sciences, Inc., or GB Sciences. TOIs number 19038 and 21062 were filed by GB Sciences requesting approvals for GB Sciences to sell cultivation licenses C120 and RC120 to ABC NB LLC and sell its cultivation licenses C019 and RC019 and production licenses P075 RP075 to AJE Management LLC. These transactions will result in GB Sciences selling all of its Nevada cannabis licenses. In addition, AJE Management LLC has requested waivers pursuant to NCCR 5.112 and 5.125 of the requirements of NCCR 5.110 regarding a review of all owners. AGE has adequately addressed the items required in NCCR 5112 and 5125 to allow the board to approve such waivers. Staff suggests that if approved, board limit AJE's 5.112 and 5.125 waivers to expire on such agenda date as AJE's next TOI application is heard. Staff identified areas of concern with TOIs number 19038 and 21062 because GB Sciences, through its licensed subsidiaries, filed late or incomplete tax returns with the Department of Taxation 72 times during the last 3 years. CCB staff have provided potential options for the board's consideration to proceed with TOIs 19038 and 21062. I am available for any questions, and my understanding is that Adam Fulton and John Poss for GB Sciences, Brian Moore and Arturo Gonzalez for ABCND, David Weiner for AJE Management are available to address any questions you may have as well. With that, Chair Nylander, I'll turn this item back to you.
Chair, may I make a quick disclosure? Member Durrett, for the record, I've disclosed this in the past. Adam Fulton represents my mom on a business litigation matter that is completely unrelated to anything that would concern the CCB, and I do believe that I can proceed with independent judgment. I don't believe it impacts my judgment in any way. Thanks.
Great, thank you for that disclosure. Mr. Colton, do you have a presentation today?
Thank you, Chairman. Today, just a quick correction, Mr. Poss was actually unavailable to attend today due to a medical issue, and so Zach Schwartz is here, who is the CFO of GB Sciences, to answer any questions. Would like to thank staff, Chief Staley and his staff, and everybody for assisting us in this transfer process. They were phenomenal to work with, and we're here to answer any questions that the board may have of us.
So it looks like this is a full out transfer of both licenses.
That is correct.
And can you give us some color on why those tax filings were not made?
Yes, and Mr. Schwartz and Mr. Weiner will address that.
Starting in 2019, I think the facility had some serious issues, loss of crops that severely impacted the financial situation over there. There was also a bookkeeper that was not filing the returns, and we didn't realize it until farther along down the line. And so as far as the late payments go, we chose to keep the lights on and to pay employees. And we have caught up on all of the tax obligations. They're current to date. As far as the late filings go, we've placed some measures in place that we believe will prevent that from happening in the future, including oversight of the bookkeeper there and filing returns early. And we believe that those will mitigate the chance of this happening again in the future. And again, we are current as of now on all our tax filing obligation.
Hello, hello, commissioners.
Please identify yourself for the record.
Oh, I'm so sorry. David Weiner. I am the managing member of AGE LLC, the Management LLC. We started this process almost 2 years ago. Upon the start of the process, we injected about approximately $500,000 to assist them to keep their lights on until the process go through. As mentioned, they were unable to keep up with their tax payments due to COVID, due to crop loss, due to inventory, and a variety of other reasons. I was doing some financial oversight for them. It became apparent during this process that the bookkeeper was filing late. for a variety of reasons, which she had really very little explanation for. We've now put in place some measures to file on the 15th. We'll be filing on the 15th. One instance was that she emailed the wrong email address, didn't realize for a month that had not been received. So from henceforth, we're going to be filing on the 15th. We're going to be emailing, delivering a hard copy with our payment. So I don't see this as an ongoing problem in the future. And we've also brought in additional financial management to oversee that specific issue.
So you essentially loaned them the money that to keep the lights on, as you said, but also to repay the tax obligations.
Well, there wasn't sufficient money at the time. COVID hit. We were able to start dramatically paying it down in the latter part of 2020 and the early part of 2021. And I think we paid off the entire tax liability probably 3 or 4 months ago.
Okay. And what is your background in terms of compliance and cannabis? I know that you've spent some time in California. Maybe give us a little bit of your background.
Sure. I started off I have a degree from business finance from UCLA, MBA, and I got involved with the cannabis industry almost 2010, started a company to sell hydroponic equipment. That was a relatively successful company. I went on to invest in various other cannabis companies, one of which was GB Sciences. So I actually invested quite heavily early on, maybe 5 years ago, significant amounts of money. And that I learned the actual process as an investor in GB Sciences, just overseeing what was, from an investor perspective, I started learning. I met several people that I really respect in terms of operations, and they were hired by the company to run GB Sciences as licensed entities at that point. So I've been in the business. I've learned the business over the last 10 years. I'm active in a company that actually is based in Colombia, which is cannabis is legal there now. And I've gotten very involved with understanding strains and the latest technologies for micropropagation, for temperature controls. And if you've ever been to the facility, it's all built out with clean rooms. It's pretty much state of the art. They spent quite a bit of money to build it. It's about 1/3 built out, and our intent is to inject additional capital to complete the build out of that facility. I'm not sure I answered the question, but
No, it's sort of just from reading the material, it looks like you got skin in the game as an investor, and that's how you got sort of started down this road. Let's see if there's questions from the board from either the applicants or Mr. Staley.
I have a question. Are any of the proposed new owners, do any of them live in Nevada?
well, I have a house here, but 3 live here.
I'm sorry,
Three
three of
smaller
them do?
investors, and the people that operate the company are also small investors in the new entity that was created to buy it. So I think there's 3 of them that do live in Nevada.
So who will be managing it, and do they live in Nevada?
Brian Moore is one. Jeff Nassif is another. And I live here, so I'm going to be much more active once the ownership changes, hopefully, and being on a daily basis there, working at least financial management.
Does Brian Moore live in Nevada?
Who?
Brian Moore, does he live in Nevada?
He spends, I don't know if he's a resident here or Puerto Rico. He comes back and forth.
Okay, and he'll kind of be like the main go-to running the
Jeff
show.
Nassif is the day-to-day manager.
Okay.
And Brian Moore is more of a strategic. And, as we said, we're building out the rest of the facility. Brian's very involved in that project. Yeah, so that's.
So like who kind of, if there's not, if things are going wrong and there's not compliance going forward, who do you think the buck stops with, basically?
Once I own me.
Thanks.
Sure.
Further questions from the board? Okay, if there's no further questions, I'll bring it back to the board for deliberation. Obviously, we've got these unpaid taxes that occurred over a lengthy period of time, which are somewhat troubling. I do think I'm starting to understand where the new management is, and I guess I'd like to get some more color on what's been done by the company to ensure that these types of violations aren't going to occur again.
Member Durrett, for the record, I agree exactly with those sentiments. I don't want to hold up the transfer, but I do think we need to look a little further into whether the delays in filings were violations and whether or not there should be a settlement agreement relating to those. And if in that process, maybe there could be a further discussion of maybe within the plan of correction discussion of how that is going to be avoided going forward. And then it could all be wrapped up nicely.
Yeah, I'm kind of in the same spot. I think I'm comfortable approving the transfer, but I think we'd probably want to have the AG's office take a look at this, make sure that staff can be comfortable, and so we've done this on a number of occasions, and this seems to fit into that category, at least from my view. Dr. Young or Member Merritt?
This is Member Young. I'm in agreement with you, Member Nylander, that I'm comfortable with moving forward with the transfer, but obviously there's some issues and some questions that need further looking into by the AG's office.
This is Member Merritt. I agree also.
Okay. Well, let's go ahead and try a motion to approve the transfer. But the tax matters and any other compliance matters will be further discussed by the Attorney General's office and our staff. And I guess I'll just say that's a motion. I just made the motion so that we don't have to repeat each other. So, and I don't think.
Member Merritt, I second it.
Okay, we've got a motion and a second. And I don't believe there were any conditions on this, were there, Mr. Staley?
Chairman Nylander, the AJE had requested, let me go back to the report here. AJE had requested waivers pursuant to 5112 and 5.25. Is that correct, Adam?
Yeah, that is correct.
So I would suggest, I think you may have proposed language for conditional approval. Typically, we request that if the board approves the 512 and 5125 waivers, that they remain in place until AJE appears again before you with an additional TO.
Very good. We'd go ahead and amend the motion to grant, but the waivers would be limited to expire on the day that the next TOI item is heard by the board. Further questions on the motion or this item in general? Seeing none, all those in favor signify by saying aye.
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 Any opposed? Seeing none, the motion carries. That brings us to item 4C.
Thank you.
Thank you, Mr. Chairman, members of the board. My name is David Staley, Chief of the Investigations Division for CCB. Item C is a TOI application for Mesa Oils LLC or Mesa Oils. TOI number 20006 requests approval for 5 new investors to acquire membership in Mesa Oils, joining Harris Riddoff, who was previously the sole member. Staff identified areas of concern with TOI 20006 because it appears that the new investors have already funded the requested capital calls, participated in membership voting, and functioning as active members of Mesa Oils. As a result, it appears the transactions contemplated in TOI 2006 have been substantively completed without approval. CCB staff had provided potential options for the board's consideration to proceed TOI 20006. I'm available for any questions, and my understanding is that Derek Connor, Harris Ridoff, Richard Balitz, George Patello, Gustavo Loez, and Paul Schloss are present today to address any questions you may have as well. With that, Chair Nylander, I'll turn this item back to you.
Very good. Mr. Connor present?
I am. Good morning, members of the board, Chairman Nylander, Director Klimas, and of course, staff. I want to thank Mr. Staley and also Mr. Cole, I think he's back there, for working with us on this investigation. I would also like to take a moment to introduce the proposed members of the company. I feel like oftentimes we look at these numbers and we skip the actual people that are behind them, but I'm very proud to introduce Mr. Harris Ridoff. Saying he's a seasoned local businessman is not a comment on his age. However, happy birthday. He turned 87 this weekend. Mr. Ridoff.
Happy birthday, Mr. Ridoff.
He's well known in the community. He developed Soho Lofts as well as several other properties around Henderson. He's had a long relationship with regulatory bodies in the state and a long and good relationship, I might add. We also have Mr. Richard Balitz. He's also a property developer that helped build several multifamily homes, both here in the Las Vegas and Henderson area, as well as around the country. We also have Mr. George Michael Vitello. He goes by Mike. He is in the food industry in Chicago, which kind of harkens back to the days of when Chicago was a large meat packing area. If I told you how much meat he moved to this country, you would be shocked, but it's a lot. And lastly, we have Mr. Paul Schloss. He has been a member of the industry since it was still under medical. Paul is kind of the nuts and bolts at one of the cultivation places that helps get the products out to the community. Now, with regards to the areas of concern, it's interesting when I go to court, I've had a chance to look at a brief. I have a chance to respond to the brief here. I don't get a copy of the report that you guys have been given. So I don't really know specifically what issues were raised by Mr. Staley in the report. However, in my follow-up phone call with Mr. Cole last Friday, primarily his concern was that money had been given to the company by the proposed members, and that money had been used by the company. Now, as I understand the regs, I don't believe that cash would equal a transfer of control. I understand the board would have concerns about it, and we are happy to answer any questions that you might have.
I guess just the basic question is, was the money given in exchange for a membership interest or control of the entity?
Well, yes, that was money that they were using to purchase their interest in the company. Now, those interests, the documents, I don't think we can just dismiss them out of hand. Those documents said that, and the operating agreement of the company, in fact, says that no transfers of interest may be done except in accordance with law. As the board is well aware, under 678B380, the board is granted the authority by the legislature to issue regulations governing the transfer of ownership in an entity. That's governed by 5.110, which governs the transfers of ownership. I do not believe a true transfer of ownership has occurred because we are here pursuant to subsection 1 of 5.110, seeking approval of the board, which is accordance with law.
Chairman Nylander, if I may.
Please, Mr. Staley.
David Staley, Chief of Investigations for the CCB. During the interviews that our agents had with the several potential owners, Balitz, Harris, and Schloss, they indicated that they had been participating in capital calls as well as discussing and voting on collaboration between Mesa Oils and Redwood, a relationship that's discussed in the report. So while the actual transfer of shares may not have occurred, it appears that the individuals were operating as the members of the LLC. They had been operating as members of the LLC. I think the question would be whether their participation in the operations of Mesa Oils as members is a distinction from the actual receipt of the shares themselves.
And with regards to the comments during the investigation regarding voting, I would like to point out it is my understanding that no member meetings have been held. The sole member of Mesa Oils is HRSC LLC, and the sole member of HRSC LLC is Mr. Ridoff. He hasn't held any meetings with himself. There have not been member meetings with the proposed members. There have not been true member votes. We would have turned those over to Mr. Staley if they were available. There would have been meeting minutes. They simply don't exist. Therefore, they were not turned over. Again, our position is, I don't believe the transfer has occurred. I believe that, again, we're happy to respond to any questions the board has regarding the issuance of shares or transfer of shares to the members, because that haven't happened yet. But we are also happy to discuss the money and how it was used if you have questions with that regard.
So there is a board of managers, but it's just Mr. Ritoff.
Mr. Ridoff is the manager of Mesa Oils, yes.
And these individuals who invested did not participate in management?
No, they did not. This is why we're here, is to have them approved as members. And at that point, they will be invited to attend any member meetings or vote as any other member would.
Understood. Did you have any other remarks, Mr. Connor?
I would ask, I guess, like the prior agenda item, if there are additional concerns, I would request that the transfer of ownership be approved and we'd be able to address those concerns like the prior licensee and several licensees prior to them.
Very good. Further questions from Mr. Connor from the board? Seeing none, I'll bring it back to the board for deliberation. Thank you, Mr. Connor and Mr. Staley. It does appear that there's a genuine dispute about, whether a transfer did occur and what types of influence was being exerted or not in respective preparation for the transaction. These individuals, I don't have any issues with. I don't have any issues with the corporate structure. But I do, and I'm prepared to go forward, but I do think we should have the AG's office and staff look into the notion of whether there was an unapproved transfer or not. I understand the applicant's position, but that's sort of where I'm leaning, but let's see what the pleasure of the board is.
Chairman, I have a question about logistically, if we approve the transfer and then, okay, so Mr. Ridoff would still be an owner, right? Because if we approve a transfer and he's not an owner, then he's not a licensee, and if there were violations, then he would no longer be involved, but he is still an owner under the proposed, okay, all right.
Correct.
So I don't have any issues. I would support that.
The members of the board? Mr. Young, Ms. Merritt?
I don't have any questions.
You do I.
Okay. Member Durrett, you want to try a motion on this one?
Yes, please, thank you. I move to approve the TOI number 20006 relating to Mesa Oils under agenda item 4B. The board would be approving the transfer of interest, but sending the matter back to the AG's office to look into potential violations of the transfer of interests regulations.
Very good. Is there a second?
This is Member Young. I'll second that. I agree.
We have a motion and a second. All those in favor signify by saying aye. Aye.
Aye.
Any opposed? Seeing none, the motion carries. Thank you.
Thank you all very much.
Thank you very much.
I believe that brings us to item 4D.
Thank you, Mr. Chairman, members of the board, David Staley, Chief of Investigations, CCB. Item D are TOI applications for Gravitas Nevada Limited, or Gravitas. TOIs number 2100003 and 2100010 through 21000013. Request approval for an ownership-wide reorganization wherein each of the company's cultivation, production, distribution, retail dispensary are spun off into separate distinct companies with identical ownership to Gravitas. Staff identified no areas of concern with this application. I am available for any questions, and my understanding is that Alicia Ashcraft and Barry Fieldman are present today to answer any questions you may have as well. With that, Chair Nylander, I will turn this item back to you.
Thank you, Mr. Staley. Good morning, Ms. Ashcraft.
Good morning, Chair Nylander, members of the board. For the record, Alicia Ashcraft of the law firm of Armstrong Teasdale on behalf of the applicant. I believe by way of Zoom, Barry Fieldman is available. I don't know if Director Klimas, if he's been let in. Okay. We're available, happy to answer any questions you have on this. We'd like to thank Ms. Rachel Branner, CCB staff, for all of her diligence and hard work. There were approximately 7 sub sections of these TOIs. So we appreciate her working through that with us. And again, happy to answer any questions.
So this is a complete transfer also of each, with each transaction where the new companies will accept the liabilities as well.
That's correct, Chair Nylander. There are 2 small internal transfers, 2 members with 3.5% interest and 1.67% interest. Those are both going to Mr. Fieldman, who's an existing owner, and those members are going away. And then the exact ownership that is currently in Gravitas, which is 60-40 of 2 entities, is exactly what these new entities, SFD, SFC, and SFPD, have that 60-40 same ownership. So it's just that we're breaking out those operations, dispensary, retail store, cultivation, production, and distribution, rather than being held in one company into separate individual operating companies.
Very good. Thank you for that. Is there questions from the board on this transfer of interest? There's no areas of concern. And it looks to be pretty straightforward once you get to the bottom line. Questions from the board?
Well, Member Direct, can Mr. Fieldman just say hi so he's on the record? I really appreciate that, you know, the licensees and show up and their attorneys. Just want him to say hi. That's it.
Good morning. I'm Barry Fieldman. I'm one of the managing partners of Gravitas and Green Acres, the majority member. Like Alicia Ashcraft just indicated, this is housekeeping type of things to stay in compliance with, as a structural matter, it's the same ownership that currently exists, and no real change except for the minority interest that I'm buying, one because of an estate death of one of our partners, which was for 3.5% for Professor Cummings. And the other was a 1.67% interest because of financial difficulties that a member was having, that I've agreed to buy out their shares upon the approval of this board. So it's a pleasure to meet you for the first time face to face or by Zoom, and I will entertain any questions that you may have.
Questions for Mr. Fieldman?
And just for the record, Chair Nylander, members, Mr. Fieldman remains on in the new structure as the president of each of the new companies. So he's previously the manager of Gravitas, and now he'll be the president of these 3 new companies.
Very good. I did not have any other questions or concerns.
Neither do I.
Open to it.
Very good. Then I think a motion is in order.
Member Durrett, I move to approve agenda item 4D, the transfers of interest requested by Gravitas Nevada, TOI numbers 21000003, 210010, and through 210013.
This is Member Merritt. I second.
Great. We have a motion on the floor and a second. All those in favor signify by saying aye. Aye.
Aye.
Any opposed? Seeing none, the motion carries. Thank you and good luck to you.
Thank you very much.
Thanks so much.
I believe that brings us to items 4E and F. I've been notified that at least one of the attorneys in this matter is asking these two matters to be trailed. There was a court hearing this morning, and I think a few people got hung up. So I'll trail these items to the end of our agenda. And I believe that brings us to item number 5. And item number 5 is it's management services agreement for Fortress Equities. Is there a presentation on this, Mr. Calamus?
Chairman Nylander, I'll read the item into the record if you don't mind.
Sure.
Chairman Nylander, members of the board, for the record, I'm David Staley, Chief Investigations for the CCB. I am here to present item number 5, which consists of a request for approval of a management services agreement between Fortress Equities ORCL LLC and 46 and 2 NB LLC. CCB staff have reviewed the agreement and found it appropriate. I am available for any questions, and my understanding is that Dean Halili, Jesse Peters, and Dawn Polanak are present today to address any questions you may have as well. With that, Chair Nylander, I'll turn this item back to you.
Very good. Good morning, gentlemen.
Good morning.
Good morning. Good morning.
Please state
So
your
I'm
names
Don-
for the record.
Yes, Don Plednak of law firm of Sylvester and Plednak on behalf of the owner, Fortress Equities Oracle LLC.
Good morning. I'm Dean Jalili, manager of Fortress Equities ORCL LLC.
And I am Jesse Peters. I am the manager and owner of 46 and 2 NV.
Very good. Why don't you just give us a quick overview of the management agreement?
Do you mind? Sure. So thank you. The management services agreement is part of a larger transaction whereby Fortress Oak Ridge, its related entity, also owned and managed by Mr. Jalili, has leased a property in Pahrump to Mr. Peters' entity. We're also in the process of transferring the license pursuant to a license purchase agreement that was entered on to the same date as the agreement that's before you for approval. Given the timing that's involved in getting the license transfer approved, the parties thought it appropriate to enter into a management service agreement in the interim so that the property could be operated in the way that it's intended. So Mr. Peters' group is doing that for us, and they'll serve in that capacity until the time, hopefully, that transfer of the license is fully and finally approved by this board.
Very good. And that is what our materials reflect. Let's see if there's questions from the board on the management agreement or the relationship of the parties. Seeing none, I think we can go ahead and take a motion on this item. And again, we don't specifically approve the language of the agreement, but the relationship that's created by the agreement.
Thank you.
Is there a motion?
Member Durrett, I move to approve agenda item 5, the approval of the relationship between the proposed entities, Fortress Equities and 2NB LLC.
The motion on the floor, is there a second?
This member Young, I'll second that.
We have a second. All those in favor, please signify by saying aye. Aye.
Aye.
Aye.
Any opposed? Seeing none, the motion carries. Thank you for your time.
Thank you very much.
Thank you.
Thank you.
I believe that brings us to item number 6. And this is a matter we've previously heard involving Green Cross and a receivership. And I think we have an update from Deputy Rath. Is that correct, Tyler?
That's correct, Chair.
Thank you, Chair Nylander. L. Christopher Rath, Senior Deputy Attorney General. I'll be presenting this item today. As you just stated, this item is continued from the October CCB meeting. As you recall, there was some dispute over the request to place Mr. Hardy as a receiver over Green Cross of America. A number of events have occurred in the meantime. Green Cross has retained Derek and Amanda Connor to represent it. And Mr. Connor will be here to present a status update to the board of where things are. But basically, Green Cross and the creditor Red Dot have come to an agreement to request a different receiver be put in place, Mr. Kevin Singer. There was a court hearing yesterday where the parties updated the court along those lines. The court will be hearing the matter again on January 27, which is after the board's January 25th meeting. Based on this, Mr. Hardy has made a written request to withdraw his application for an agent card and to be placed as a receiver. Mr. Hardy will address that issue with the board. More specifically, Mr. Hardy's request is for a withdrawal without prejudice. CCB staff and I both recommend that the CCB approve Mr. Hardy's request for withdrawal without prejudice. We could take that issue first before we get to Mr. Connor, if that is the chair's desire.
Yes, let's have Mr. Hardy approach.
Chairman and members of the board, Brian Hardy, a law firm of Marquis Arbot Coughing. As you recall, I was before the board earlier relative to the appointment of a receiver. I'd been appointed by the judge in this case after an application that was filed by Mr. Wiley and his client in the district court case. Thereafter, it appears that the Green Cross was able to retain counsel, and I commend them for doing so. They retained Derek Connor, who's done an excellent job being able to work with Mr. Riley and being able to identify somebody that they would mutually agree upon as a receiver instead of one that would be appointed by the court. I'm glad that my service, I guess, at least has been to encourage the parties to work together, if nothing else. And I'd ask that that my application for receivership be able to be withdrawn without prejudice.
Very good. Questions of Mr. Hardy? I didn't have any questions. It makes sense to me. And so you've got two applications, so I want to make sure. One was for an agent card and one was for a receivership. And are you asking that both be withdrawn?
I believe so, yes, because I think if they want to go ahead and they'll go get a new receiver appointed, once the new receiver is appointed, he's going to need to file an application for both a receivership and for the application to serve as the receiver and receive an agent card.
Okay, and this proposed to be Mr. Singer, and the court will hear that matter on January 27th?
As I understand it correctly.
And Chair, as I understand, Mr. Singer will likely be filing an application for an agent card and an application for placement as a receiver with CCB, likely prior to that hearing with the court for full appointment. So I think Mr. Connor can update us on that. And I mean, there's an option to continue the matter to the January agenda once we've got that application in and can hear that. But I think obviously appropriately, the next action item to take is to vote on the approval of the withdrawal without prejudice.
Very good. I'll go ahead and make a motion that with respect to Mr. Hardy's applications as a receiver, as well as for an agent card, that the board grant those withdrawals without prejudice. Is there a second on the motion?
This member Young, I'll second that. I agree.
Have a second. All those in favor signify by saying aye. Aye.
Aye.
Aye.
Any opposed? Seeing none, the applications with respect to Mr. Hardy are withdrawn without prejudice.
Thank you. Appreciate your time again today.
Thank you.
Chair, and I think Mr. Connor is ready to speak to the status update. We may have other interested parties wishing to speak on this matter, I think including Mr. Wiley, and there may be some other owners or other interested parties who wish to speak after Mr. Connor.
Good morning again, Mr. Connor.
Good morning again, Chairman Nylander, members of the board, Director Klimas, and again, staff. I think Mr. Rath did an excellent job, as well as Mr. Hardy, explaining where we're going. We held a meeting with the shareholders through council telephonically at my office last week. I think the shareholders understand and they've all agreed to the appointment of Mr. Kevin Singer as the receiver. I believe some of the shareholders are present. One of them is Dr. Musa Kohani. If you want to step up and say hello. Oh, are you okay? He is also a seasoned physician. So again, not a comment on his age. Thank you. So the parties, Mr. Jason Wiley and I are the attorneys for the parties in the case. We are working towards getting a stipulation in place in the matter pending in Department 13 before Judge Denton. Like Mr. Rath stated, the next hearing is January 27th of 2022. We anticipate we will have those motions filed and hopefully approved prior to the next hearing if we can. So that is essentially the status.
Great, Mr. Is there others who wish to present today?
Yes, Mr. Chairman. Briefly, Jason Wiley on behalf of the law firm, of the law firm Wiley Peterson on behalf of Judgment Creditor Red LLC. Both Mr. Hardy and Mr. Connor have conveyed our position as well. It's our intent to get the stipulation appointing Mr. Singer as receiver over Green Cross to the court in advance of that January 27th hearing. So that'll get rubber stamped, and we anticipate Mr. Singer to apply for agent card and receivership with the board in short order as well.
Yeah, and I would encourage you to get Mr. Singer to apply for his agent card as soon as possible so that we can start work on that to shorten up the timeframes a little bit if we can.
I will be contacting him regarding that today.
Thank you. Further questions on this matter? Well, it seems to me we ought to probably refer this matter back to staff and just hold it, and then hopefully everything goes as planned that the parties have agreed on, and there'll be a hearing in the end of January. Does that cause you any hardship, Mr. Connor, or your clients?
No, I believe that will be okay.
Okay. So, let's see, what's the pleasure of the board?
Member Young, so this issue with Mr. Singer as the receiver will probably be looked at maybe in February then, because of their hearing occurring after our next meeting?
Well, Member Young, we may be able to do it in January if all the parties can stipulate and the court approves the stipulated order for a new receivership. Plus, if we have Mr. Singer's application in as soon as possible, I think we could handle that on the January meeting. I think we could make that attempt. So I might suggest we put this back on the agenda for the January meeting, and we'll get as far as we can in the interim with all the parties.
And this is Jason Wiley on behalf of Red Dot. It's the intent of Mr. Connor and myself to stipulate to the appointment of the receiver. That January 27th hearing is not going to be a motion where the parties are going to argue as to the merits of the appointment. It's hopefully just a status check to ascertain the status, with the fact that the order would have already been granted appointing Mr. Singer as receiver.
Okay, well, I think we should have just refer this over to our meeting in January, just continue it to our January meeting, and then we'll see where everyone's at. And at that time, you can request a withdrawal of the item if it looks like you're it looks like everything's going to go as stipulated. So I don't think I need a motion on this, Mr. Rath. I can just continue this over to the next monthly regular meeting.
Yes, I think you can refer it back to staff and continue it to the next meeting in January. And when we get to that point, the board will at least need to vote on approval of Mr. Singer.
Okay, I'll go ahead and refer it back to the staff for continuation, potentially at our next meeting in January if it's ripe. Thank you, gentlemen, for your time.
Thank you. Happy holidays, everyone.
Thank you very much. And thank you both to Mr. Wiley and Mr. Hardy. It's always a pleasure to work with courteous and professional attorneys. It's not always that way. And I think that I enjoy to note it when it is the case. So thank you both. And thank you, board.
Thank you. I believe that brings us to item number 7.
Thank you, Chair. So we have Deputy Director Michael Miles, who's going to present on agenda item number 7.
Good morning, board members. For the record, I'm Michael Miles, Deputy Director of the Cannabis Compliance Board. This item is for the board's approval of the changes to the NCCRs that would allow for the certification of female and minority-owned businesses. The proposed diversity certification process will be used as seen in the proposed application regs to award diverse applicants 30% of all future establishment licenses when the number of licenses are limited. 30% comes from the many nationwide standards and federal procurement standards. This will help us to ensure that we are focusing on implementing legislative mandates given to this board to ensure an increase in diversity among cannabis owners and operators. Changes to Reg 1 are the definitions of diversity applicant and diversity certifying entity. Reg 4 covers additions to category violations regarding the certifying process. Reg 5.045 covers the certification process and also includes a petition process to add more certifying entities. With that, I will turn it back to Chair Nylander.
Yes, and if you could describe, I understand there were at least one workshop on this. Was there potentially 2? Can you give us the background on that?
Correct. We had a workshop on November 10th where we discussed the certifying process.
And were there any objections at that time?
I do not believe there were any objections to the certifying process at that time.
Yeah, so because we did hear in the public comment this morning, at least one objection to the process. So can you address that?
I'm not 100% sure how it would affect them, because this is for future rounds. I guess it would affect them to the fact that they would have to certify to apply for future licensing rounds if they want to be included in the diversity process where they would get the 30% of all licenses set aside for diversity applicants. Other than that, this is just for future applicants and future owners. Again, we're setting aside 30% of all future licenses. The process that hasn't been approved yet is setting aside 30% of all future licenses to be awarded to diverse applicants. And diverse applicants under our statutes are limited to female and minority-owned businesses.
And that's clearly defined in the legislation, correct?
Correct.
And the 30% is clearly defined in the regulation. I'm sorry, in the statute.
It is not in the statute. It is in the regulations that will be workshopped this afternoon.
Okay. Well, is there any harm to holding this item and then including it as part of the package for the other workshops? I know we're trying to get a head start on some of these things, but
and that is the exact reason, to get a head start to allow these minority and female-owned businesses to start the certification process as soon as possible. So they will have months, probably at least 6 months before the licensing round to get certified, so they can get included into that potential 30% process.
so these would be essentially new applicants, right?
Correct.
Potentially.
Correct.
Well, let's see what the pleasure of the board is and if there's questions in respect of this draft regulation.
This is Member Young. I had a question, if I may. In terms of the certifying process, is it cost prohibitive? Is there a significant expense required in the certification process?
No.
Or do we know?
One of our investigators, Jane Maurer, spoke extensively with the certifiers that are included in our regulation, and it's generally just a couple $100 to go through the process. And generally, it takes a couple months to get through the process, depending on the cooperation of the owners.
Further questions from the board?
I have a couple questions. Remind me again, the 30%, we're saying we're gonna set us, the goal is to set aside 30%. Does that apply to consumption lounges also?
Correct.
And that is in statute, 30%
No.
is in statute.
The 30% is nowhere in statute. The 30% came from basically subcontractors of big federal construction projects require, I believe, 27% of the contractors to be minority and female-owned businesses. So we just,
But so if we have the, and we've already been through this, and then I get confused like after I get it cleared up in my mind. So the consumption lounges already have the social equity component where half of those are set aside. So where does the 30% play into that?
social equity, as been discussed at the social equity subcommittee and specified specifically by their chairman, that social equity really has nothing to do with race or gender. It's more with how you were affected by the war on drugs and the locations you're at and convictions you maybe had. This is a completely separate item in our statutes that says we must take diversity into account when awarding licenses. And diversity is limited in this case to adult use licenses to female and minority owned businesses.
And I totally get the difference between social equity and diversity, but I'm wondering, so half of the consumption lounges that are not awarded to dispensaries are going to be awarded to social equity applicants. So then 30% of the half that don't go to social equity applicants are going to go to diversity applicants.
Yeah, right now there's 20 set aside for individuals. Half of those are going to go to social equity, half are going to go to general applicants. Of those 10, 30%, so 3 will go to specifically diverse applicants.
Okay.
But that's also just for this. All future licensing rounds will go for the same way.
Say that again. Sorry.
All future licensing rounds will, if there's a limited number, let's say we get 100 cultivation licenses to award, 30% of those will go to diverse applicants.
Can we do that in regulation versus statute? Does the legislature not need to do that?
Our Attorney General think we can.
Okay. And then one other question. So I can kind of see the issue of, well, okay, as a diversity applicant, I now have to do something that non-diversity applicants don't have to do. Could we balance it out with the fees? So whatever the fee to do this is, a non-diversity applicant increase their fees by that amount, so it's a level playing field? Or is it too late? Because we haven't set the fees yet, so we could address that later. I don't think we'd be holding these up. So say
there is, sorry, I don't mean to interrupt. We don't charge any fee for the certification process. The certifying entities will charge a fee, which again is around a couple $100.
Yeah.
Our fees are set in statute.
Yeah, that's right. Okay. All right. Thank you so much.
This is
Tyler. Oh, go ahead, Member Merritt.
Okay, with our workshop that is planned for later today, do you think there will be more clarity if we were to not take the vote and wait for the workshop today?
This is Tyler Climas for the record. Member Merritt, so we will be discussing social equity applicants later today. Diversity will be brought up. The reason that this is before the board today and we moved on this a little bit more quickly than the lounge regulations was to allow, if the board was in support of moving forward with this kind of diversity certification, to give those applicants the time to get certified. I believe the organizations which deal with the certification in a number of different avenues and with a number of large corporations, they indicated it could be 30 to 45 days, but it could take as long as 90 days. And so given that, knowing that we are looking at a lounge application period, or the plan is in mid-year or prior to mid-year next year, we just wanted to ensure that there was time for individuals to get certified. And I'd also like to add, Member Durrett, if I think it's a great idea on the cost and being able to somehow help with those costs on the back end. And while we may not be allowed to do that or available to do that per statute now, that is something that we certainly could look at during the legislative session. I think that is a great idea.
Further questions? Well, let's see what's the pleasure of the board. I understand that moving forward conceptually is a good idea because it will take these applicants time, but I also don't want to rush this process. And even though we did workshop this and it did not appear there was any opposition, there is now opposition. So perhaps we should hold it and see if it becomes clearer as a result of the other upcoming workshops. But that's just my thought. Let's see what the pleasure of the board is.
Member Durrett, for the record, I'm in the same spot again. I do not want to hold these up. The board has done so much work on these. They gave ample notice, ample opportunity for people to participate. It's really unfortunate that people didn't, but I do think since there is still confusion that we should bump it if possible to discuss it further, but bring it back as soon as possible, because the people that are going to be disadvantaged by us moving it are the people who benefit from this statute. So if we do move it, I would like to see it back as soon as possible so that people can start applying for these. But I would support your same sentiments.
Yeah, I'm in agreement with that. Mr. Klimas, do you have any thoughts on that?
No, and I understand it. And because it's been workshopped, you know, and obviously we may not be able to add it officially to the agenda for today, but it will be a discussion point along the greater social equity conversation. And again, the fact that this particular regulation has been workshopped, or the proposed regulation has already been workshopped, you know, it would take another 30-day notice. But if we can get some more clarity on it, I mean, there still may be opportunity to get it on the books even prior to the entirety of the lounge regulations, which would allow for some extra runway. But I certainly understand where the board's coming from, and we will make anything work that we need to.
Well, I would go ahead and move that we refer this back to the staff for further consideration at this time. And then we'll see if we get some clarity from even this afternoon's workshop. And I know there'll be other workshops as well. So, and we'll try to get it on as soon as possible. So is there a second to that motion?
This is Member Young. I agree with the comments said, and I would second that motion.
Okay. There's a motion to refer it back for further consideration and a second. All those in favor signify by saying aye.
Aye.
Any opposed? Seeing none, we'll refer that matter back to staff. And I believe at this time we're scheduled for item 8. Why don't we take a 10-minute break, and we'll come back in 10 minutes at 10:35. Thank you.
Still on his jacket, right? He's like, talk about human trash. Like, he's just like, as he's driving off, right? He's in the car. He's probably, as the bike finally dies, and he's like 100 feet away from us. Like, we just sit as a light talk about it. Let's see.
All right, everyone, we're gonna get started here in a minute.
Tyler, are you ready to go?
Yeah, Member Nylander, we can get started when you're ready.
Okay. I'll go ahead and call the meeting back to order. We left off at item number 8. These items are all requests to extend certain inspection deadlines. We've got quite a few of them on today. The reasons range from having jurisdictions where a moratorium has been lifted. They're still working on the logistics of local approvals. Others where there's attempts to lift a moratorium. Some are just supply chain related, COVID related delays, things of that nature. So, but what we have are differing requests. Now, what we've done in the past is typically we've allowed these extensions for a 1-year period and then have the applicants come back and give us a progress report. So we'll, I'll call them one by one and then we'll just see how the board wants to handle them. But that's just a little recap on these to refresh everyone's recollection. So let's dive in with item 8A, Deep Wellness Center.
Thank you, Chair. Members of the board, good morning. Steve Gilbert, Chief of Administration for the record. Agenda item 8A is for Nevada Wellness Center LLC. Nevada Wellness Center requests an extension of the February 5th, 2022 deadline for a period of 6 months to perfect its conditional license RD050 within the Clark County jurisdiction. In its request to the CCB, Nevada Wellness reported on its efforts to locate a site and its efforts to secure a site, which includes signing a lease and a purchase sale agreement. Staff have identified no areas of concern. I'm available for any questions, and my understanding is that Frank Hawkins is present today to give a brief presentation and address any questions you may have as well.
Thank you. Is there an applicant present today? Mr. Hawkins or a representative from the company?
Of course. Good morning. I'm Theodore Parker. I represent Nevada Wellness Center. I've met several of you here. Let me thank the board, staff, especially Ms. Balducci and Mr. Gilbert for all of his assistance. Nevada Wellness Center, as you know, received a Clark County license through a settlement last summer. Unfortunately, it took some time for the approval for the transfer of the interest of that license, which didn't come until the end of last year. Between the end of 2020 and now, Nevada Wellness Center has tried diligently to find a location, and it wasn't until recently that we found a location. It was strange, and let me say strange, I'm using that delicately. It seemed that several times after Nevada Wellness Center or its commercial real estate agents would find a location, after the seller determined that Nevada Wellness Center interested in buying the location, for some reason the prices seemed to increase without reason. And we still don't understand why, but it was certainly more than coincidental, we believe. But I will thank again Ms. Balducci and Mr. Gilbert for going through all of the information we provided. We provided a history of all of our efforts, and we have already submitted our request to Clark County for a determination on the location. And I believe it's going in front of the Clark County Board on January 19, 2022. We are a little concerned given the pandemic, given the cost of construction, and given delays with materials. And based upon those concerns, I'm asking this board to increase it from 6 months to 1 year, just in case, because we prefer not to come back again. If that would be suitable, we would certainly request that.
Yeah, and the record. Yes, thank you for that. Yeah, and our record is complete in terms of all the efforts the company's gone to with, a lot of difficulties and ins and outs along the way. I was going to suggest 1 year anyway, so just to give you time to sort everything through. And, and then if for some reason you get hung up again, you can come back in a year and we'll reevaluate it then. But that's kind of where I was at. But let's see if there's questions from the board. Seeing none, I believe a motion's in order to grant the extension for 1 year.
Member Durrett, I move to grant the extension for 1 year.
Very good. Is there a
For
second?
agenda item 8A relating to Nevada Wellness Center.
Member Merritt, I second.
We have a motion and a second. All those in favor signify by saying aye.
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 This is Member Young. I just had the clarification is the 1 year from the February date, not from today's date, correct?
Correct. Does that sound right, Tyler?
That is correct.
Okay. I know we got jumbled up on one of these a couple months ago, and I think that thank you for remembering that, Dr. Young. It's 1 year from February 20 or February 5th. Okay. All those in favor signify by saying aye.
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 Any opposed? Seeing none, the motion carries. Let's take item B.
Thank you again.
Thank you, Chair. Agenda item B is for Deep Roots Harvest, Inc. for C-185, RC-185, P-121, and RP-121. Deep Roots requests an extension of the February 5th, 2022 deadline for an additional 6 months to perfect its provisional medical cultivation production licenses, C-185 and P-121, and conditional adult use cultivation and production license, RC-185 and RP-121, all within the West Wendover jurisdiction. In its request, management indicated that extenuating circumstances are related to the city of Wendover's approval process for its amended cannabis regulations and substantial delays caused by the city in obtaining a legally required appraisal of the city-owned real property. Staff have identified no areas of concerns, and I'm available for any questions, and my understanding is that John Marshall and Richard Williamson are present today here in Carson City to give a brief presentation and address any questions you may have as well.
Good morning, Mr. Chair, members of the board, and Director Cannabis. As Mr. Gilbert stated, my name is Richard Williamson, attorney for Deep Roots Harvest, Inc., and I have with me John Marshall, who's the Chief Operating Officer.
Mr. Williamson, if you could approach the microphone, we're having trouble hearing you.
Sure, I'm sorry, how's that?
Much better.
Great. As I mentioned, I've got with me John Marshall, the Chief Operating Officer of Deep Roots Harvest, Inc. as well. Deep Roots Harvest has been diligently pursuing the cultivation and production facility in the city of West Wendover. There's a couple steps that had to take place for that. The city regulations needed to be amended to allow for an outdoor cultivation and production facility. We needed to negotiate a lease option to acquire and use that property. And we also, or the city, required an appraisal of that property. And there was delays with each steps. The good news is we have executed a lease. The appraisal was completed. The special use permit has been approved. And we look forward to proceeding with construction in a reasonably expedited fashion and hope to have construction completed next summer and obtain final licensure after that. And so we are requesting a 6-month extension from the February 5th deadline.
And Mr. Williamson, are you confident you can get it done in 6 months?
I will say reasonably confident, Chair Nylander. We're certainly hoping to. Obviously, if it's easier for the board administratively to do 12 months, we've got no objection. But at least as long as we don't run into any inordinate delays, we are hoping to have it done by July.
Okay, thank you for that. Let's see if there's questions from Mr. Williamson right now. I don't see any, so I'm going to go ahead and have staff read item C into the record while you're there.
Thank you, Chair. Agenda item C is for Deep Roots Harvest, Inc., RD 397. Deep Roots requests an extension of the February 5th, 2022 deadline to perfect its conditional adult use retail store license, RD 397, within the city of Las Vegas. Specifically, a 6-month extension was requested. Deep Roots reports it has spent the past year pausing and starting construction of its Las Vegas location due to the impact of COVID-19 and subsequent supply chain issues. Staff have identified no areas of concerns, and John Marshall and Mr. Williamson are still present to comment.
Thank you, Chief Gilbert. As Chief Gilbert summarized, we've been moving diligently forward on this location. We're actually even much further along with this location in the city of Las Vegas. We anticipate completing construction in January. It's possible we might even have final inspection prior to the current February 5th deadline, but in an abundance of caution, we did want to request a 6-month extension to allow for unforeseen construction delays and the final inspection and final licensure of this location.
Questions from the board? Seeing none, why don't we try a motion? We'll take these two together, items B and C. With respect to item B, I would favor 1 year. And then on item C, let's go 6 months. That would be my recommendation, but what's the pleasure of the board?
Member Durrett, I would move to approve the request for an extension in item B for 12 months from today's date. We're doing today's date, right? No, I'm sorry, 12 months from February 5th, 2022. And then for item C, I would move to approve 6 months from February 5th, 2022.
Questions on the motion? Do we have a second on the motion?
Member Merritt, I second it.
We have a motion and a second. All those in favor signify by saying aye.
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 Any opposed? Seeing none. Thank you, gentlemen, and Carson.
Thank you very much.
Thank you.
Let's take items 8D and E. Mr. Gilbert, if you could go ahead and hit those both now at this time.
Yes, Chair. Agenda D, Green, is for Green Mortar, Nevada, NLD, LLC, RD 0504. Greenmart requests an extension of the February 5th, 2022 deadline for an additional 180 days to August 4th, 2022 to perfect its conditional adult use retail store, RD 504, within the city of Las Vegas jurisdiction. Despite its efforts to perfect license RD 504 by February 5th, 2022, several unexpected construction issues outside of Greenmart's control have arisen and are likely to cause delays to the timeline of the construction. These issues include but are not limited to structural issues, which are listed in its request letter. Staff have identified no areas of concerns. Agenda item 8E is also for Greenmart in Nevada and LV LLC, but for RD 511. Greenmart requests an extension of the February 5th, 2022 deadline for an extension of 14 months from the date on which the city of Henderson lifts its moratorium. I want to note the CCB staff have recently checked back with the Henderson jurisdiction, the business operations manager, who confirmed Henderson is in a holding pattern with the co-location requirement until the city council decides to take up the issue at a public meeting. Staff have no areas of concerns with this one, and I'm available for any questions. My understanding is that Maggie McCletchy is present and Jeff Green is present via Zoom to give a brief presentation and address any questions you may have.
Good morning, Chairman Nylander, members of the board, Director Klimas, and staff. I'm Maggie McCletchy, also here in addition to Jeff Green, who's the Senior Director of Construction and Facilities. I also have here with me Chris Collins, the Director of Operations for Greenmart of Nevada and LV LLC. And I also have Scott Sahusky, who's the IANTHUS Senior Manager of Facilities. Construction issues are a little bit above my head. And so if members of the board have any specific questions about the construction issues that have arisen, they are here and available to address those questions. Just by way of clarification for RD 504, which is the City of Las Vegas license, we requested, I believe, 180 days, not 108 days, Mr. Gilbert. And I would actually like to amend that request for it to be an extension of a year from the February 5th, 2022 date. In addition to the injunction in the 8th Judicial District and waiting on the transfer approval to IANTHUS for ownership of Greenmart of Nevada and LV LLC, as Mr. Gilbert mentioned, there have been a number of unanticipated construction delays. The City of Las Vegas dispensary is in the downtown Arts District area. It's an exciting area, but the building is older and has had a lot of unanticipated problems like asbestos that need significant work and remediation and have required extensive work that Mr. Sahusky has engaged in with the City of Las Vegas to ensure a compliant and safe building. With regard to RD 511, the City of Henderson license, it's IANTHUS's and Greenmart's position that that deadline does not run until the City of Henderson authorizes that dispensary to go forward. That's consistent with the settlement agreement in the conditional dispensary litigation. But we're here in an abundance of caution. And I know that other entities that are similarly situated have agreed to come back and appear before the board in a year's time from the February 5th, 2022 deadline to provide an update, as I think Chairman Douglas has requested of other entities that are similarly situated. That's my presentation. And if there are any specific questions about the legal history, I'm happy to provide it. And again, I've got 3 people from Ops here to answer any construction questions.
So the Las Vegas location, it's in the Arts District?
Correct. It's on Charleston.
Okay. And the primary issue there is you're dealing with an old building that needs, every time you peel back a layer, it needs another layer?
That's exactly what has happened, Chairman Nylander. Every time we think that we're getting closer to being able to, we'd actually hoped to meet the February 5th, 2022 deadline and make significant efforts to do that. But every time we turned around, there was a new construction issue that needed significant rethinking and reworking. And honestly, a number of them were safety issues that had to be resolved. And so we've been a little bit unlucky. And so in an abundance of caution, we're seeking a year now from the February 5th, 2022 deadline. We've also, just due to the passage of time, for example, we did get a special use permit back around the same time that the 8th Judicial District issued an injunction in the conditional dispensary litigation. However, due to the passage of time, we now had to do an extension application to the city of Las Vegas. That's going to be heard actually tonight. It's on the consent agenda for the city of Las Vegas. So there have been a number of things that we've had to catch up on due to the passage of time inherent in the litigation issues that we faced, but also just with the physical structure issues in the building. It is an older building. Scott Zahusky can probably answer any specific questions about the building much better than I can. But yes, every time they turn around, there's another issue.
But you don't anticipate any problems getting the extension from on the SUP?
I do not, Chairman Nylander. It's on the consent agenda at the city of Las Vegas. And so these gentlemen will be appearing there just in case there are specific questions, but both due to the litigation, but also due to COVID issues, the city of Las Vegas staff has indicated they have no issues. It's in front of the Planning Commission tonight.
Okay, thank you. See if there's questions from the board on either the Vegas property or the Henderson situation. Seeing none, I'm prepared to move forward. I think in both of these cases, we'd want to have the time limit, the time frame be a year from February 5th. It'll give them more time. And then if nothing moves in Henderson, you'll just have to come back and give us an update. It sounds like that looked like it was going to go, and now it doesn't seem like it's going to go. So
we're still trying.
Yeah, understood. Well, I'm prepared to take a motion on items 8D and E.
Member Durrett, for the record, I move to approve the request for extensions in items 8D and E relating to Green Mart, with both of those being a 12-month extension from February 5th, 2022.
Is there a second?
Member Young, I second that.
We have a motion and a second. All those in favor signify by saying aye. Aye.
Aye.
Aye.
Any opposed? Seeing none, the motion carries. Thank you.
Thank you.
Let's take item F.
Agenda item F is for Qualcan LLC. Qualcan requests an extension of February 5th, 2022 deadline to perfect its conditional license RD 591 within the city of Las Vegas jurisdiction. Qualcan did not specifically specify amount of time they are requesting. Qualcan reports that its original site location chosen did not meet the local and state distance requirements. Qualcan has identified a second location, which was put under contract, and a special use permit went before the City of Las Vegas Planning Commission at their May 11th, 2021 meeting. Special use permit then went before the City of Las Vegas City Council meeting on June 16th, 2021, at which it passed unanimously. Qualcan is expecting final approval for permitting and expects to open in the first quarter of 2022. Staff have identified no areas of concerns. I'm available for any questions, and my understanding is that Heather Cranny is present and Michael Cristalli is present via Zoom to give a brief presentation and address any questions you may have.
Thank you, Chairman Nylander, members of the board. Thank you to Mr. Gilbert and staff with regard to facilitating this request and putting it before the board. As Mr. Gilbert has indicated, Qualcan received its Las Vegas license out of the DOT litigation. Settlement agreement was executed on July 31st, 2020. Thereafter, it received its license transfer from the CCB on August 25th, 2020. The company first identified a location at 7511 West Lake Beach Boulevard. And on September 22nd, 2020, a survey there also put that property under a letter of intent, but later it was determined that that location was in violation of local and state distance requirements. It was surprising to learn later that another applicant or licensee identified that location as a potential dispensary through the review journal. However, it was our understanding through a survey that that was prohibited because there were children learning centers within the area, disqualifying the location. Thereafter, Qualcan determined that there was a second location identified at 6050 Sky Point Drive. A survey was conducted, went before planning on June 16, 2021, wherein that was final approval before the city council on June 16, 2021, where it was unanimously approved. We are currently awaiting final permitting, which was submitted in July of 2021, and we anticipate final permitting coming out of the city, hopefully before the end of the year. As you can see, Qualcan has made every reasonable and diligent effort to advance the dispensary opening in Las Vegas, and we've already advanced quite a bit of capital in the location and anticipate additional capital with the building and construction of the property. Consistent with what the board has previously done with applicants who have been similarly situated, we'd ask the board to grant the 1-year extension in anticipation of potentially maybe some construction delays going forward. We hope that is not the case, and we hope to and anticipate to have construction completed within 6 months. But in light of that chronology, we would ask the board's consideration for the extension.
Thank you for your presentation. Are there questions from the board? So just to clarify for the record, you're asking for 1 year?
Chairman Nylander, yes, I think that would be safe. We hope, as I stated, to have it done within 6 months. Just not sure, just hearing about construction issues in the field, just hoping that that won't be the case for us and that construction will be completed within 6 months. But just to be on the safe side, we would ask for a year.
Okay, well, I didn't have any questions or concerns. Members of the board? Seeing none, let's try a motion on item F, Qualcan.
This is Member Young. I will motion that we approve item 8F, Qualcan, 1-year extension from February 5th, 2022 to February 5th, 2022.
We have a motion. Do we have a second?
Member Merritt, I second.
We have a motion and a second. All those in favor signify by saying aye.
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 Any opposed? Is Member Durrett present?
Yeah.
Okay, I'm sorry, I didn't hear you. Did you or an aye?
Yeah, an aye.
Okay,
Too quiet.
sorry. The motion carries.
Thank you,
Thank you,
Chairman. Thank you, members of the board.
Thank you. Let's take item G.
Item G is for My Life Organics Incorporated, C-175 and RC-175. My Life Organics requests an extension of the February 5th, 2022 deadline. Specifically, My Life Organics requested an extension of 8 months until October 5th, 2022 to perfect its conditional adult use cultivation license, RC-175, within the city of North Las Vegas jurisdiction. The extension is requested due to unforeseen circumstances beyond My Life Organics' control, including complications resulting from COVID-19 pandemic, infrastructure, and leasing issues with the properties. Staff have identified no areas of concern I'm available for any questions, and my understanding is that Brianna Martinez, Leslie Miller are present, and Neil Bartoletta is present via Zoom to give a brief presentation and address any questions you may have as well.
Great. Let's have the attorneys for the applicants approach.
Good morning, Leslie Miller, members of the board. Mr. Bartoletta is available via Zoom, and he is the sole managing member of My Life Organics. They started their build out in Apex. but
Ms.
were
Miller, before you proceed, I have a quick disclosure to make. So Ms. Miller and Ms. Martinez are employees of Kempfer Kroll Law Firm. I am of counsel at that firm. I'm not a partner. I don't share in revenue. I have no pecuniary interest in this item and don't know what it is until I read that Ms. Miller was involved. So I'm firewalled off from any marijuana matters. In fact, I can't work on marijuana matters because I'm in the gaming space totally, and that's prohibited. So I intend to proceed and participate in this matter as I have no pecuniary interest or it wouldn't affect a person of independent judgment in my position as of counsel at that firm. Is that an adequate disclosure? The Attorney Generals, can you confirm?
Yes, that is an adequate disclosure. And as you're walled, you can continue to participate in the item.
Okay, thank you. Please proceed, Ms. Miller. I'm sorry to interrupt.
Not at all. Members of the board, My Life Organics had started in Apex, but due to lack of utilities being run to the area, they were unable to become operational within the initial time period that was set by the Department of Taxation at the time. They moved their location to La Madre Way, which is another location in the jurisdiction of the city of North Las Vegas, and they entered into a lease under which they were required by the landlord was required to exercise a purchase option, which became unconscionable. And due to the pandemic, they had a lack of investment funds. And instead of the influx that was anticipated and promised, in order to move forward with that long-term lease at La Madre Way, they were in a situation where they realized they had to get out of that lease and move to a different location. So they have not yet submitted for a change of location, but have initiated the process with the city of North Las Vegas to move their operations as a cultivation C175 and recreational as well to 1011 Alexander Road. The city of North Las Vegas approved the SUP, this special use permit at their December 8th meeting. And we're simply at this point waiting on the notice of final action, which we will timely supplement to the board as soon as we receive that approval. The members of of My Life Organics have expended several $millions just to get them to this point in time. And they intend to open a state-of-the-art facility at 1011 East Alexander Road in the city of North Las Vegas. They, like many of the other applicants, have encountered some issues with the COVID pandemic, but they're very much looking forward to seeing this through. And they do have a partnership with a multi-state operator that operates in Washington, Oregon, Missouri, among other states. And so they're very hopeful that this new partnership will allow them to set in motion what they have intended since 2018. And Mr. Bartoletta is available via Zoom should you have any questions of the applicant themselves.
Questions from the board for the applicants or Ms. Miller? Ms. Miller, it looks like you were requesting an 8-month extension.
That's correct, but in listening to the items that came before the board prior, there's the 8-month extension is based on a 6-month anticipated build out by the hired contractor, and with a 2-month additional cushion beyond the February 5th, 2022 date, it would be in the best interest of the licensee if they had the full 12 months beyond the February 5th deadline if the board is so inclined.
Great. Questions from the board?
Chairman, I have a question um, for Ms. Miller. This license was won through the 2018 licensing round. Is that correct?
No, it was won through the 2014 licensing round. They became licensed in 2014.
Okay.
And then they initiated their process at Apex. I must have I think I misspoke when I said 2018. I intended to say
no.
2014.
So I would imagine whatever they had in their application at the time and their SOPs deviates greatly from where they're at now. So have those been updated to reflect the issues, and that whatever was in their application and in their SOPs, that's not reflective of what's going on now?
Absolutely. So they had actually gone to their final approval pre-opening meeting with the Department of Taxation at the La Madre Way location. And we have yet to submit for a change of location because on December 8th, the city had just approved the move and the zoning requirements for the Alexander location. So we have a transfer of interest that will be submitted to reflect the new partnership with a multi-state operator within the next 5 days, and a change of location that will simultaneously be submitted with it as well. And the SUP was just granted, and that will go as part of the package so that the CCB is completely aware of the entire picture of what it means for the new location. And Mr. Gilbert we've been working closely with him and he's been exceptional. So we've been informing staff all along the way and the investigators of the current situation of the licensee, the pending transfer of interest and things of that nature.
Thanks. Chairman, it's sort of an open-ended question. I don't expect anything to happen at this meeting, but maybe it could come back as an agenda item to have some metrics going forward of what needs to be completed by this February 5th, 2023 hearing, because, there's licenses like this that are, there's such a wide disparity between the ones who have almost completed their construction and they did it in a short amount of time versus ones that, it's now been 7 years. So I would like to ask that come back as an agenda item for there to be a discussion on what before that 2023 meeting, what are we going to base our extensions on? What does extenuating circumstances mean? And because this is one of those older ones, and because again, from my personal point of view, I saw people make great sacrifices to complete their buildings, I'm not going to be able to support this one.
Yeah, so for the broader question, I think our executive director has been thinking about perhaps procedurally how we should handle these going forward. And I don't know if he's prepared to discuss that now, but I know that he has been thinking about sort of the process and how to maybe refine this and make it more efficient. Because we do, as you said, we have such a desperate, factors in play in all of these different applications based on their own unique circumstances and based on the jurisdiction they're in. I don't know, Tyler, did you want to comment on that?
Sure. Thanks, Chair. I think what we'll be looking at, given all these 12-month extensions, is what this universe looks like in 2023. When we took over, right, the whole reason or the purpose of this exercise was because we had these licenses that were outstanding for 7 years, some for 6 months, some for 3 years, all across the board. And so even though there's quite a few extensions happening, obviously a pandemic played a role in that. I do believe, Member Durrett and Member Nylander, throughout the next 12 months, we're going to take a lot of these off the docket, and we will have, and through that process, at the same time, we'll refine how we deal with extension requests moving forward. But I think our hope was that in a year we'd get it all cleaned up. Obviously, given things that have happened, we're now looking at 2 years to get it cleaned up. But I do believe we're making progress. And to your point, Chair, at the same time, we'll likely change the way we deal with these requests, or that staff makes its recommendations once this 12-month period is over.
Okay, yeah, that makes sense. Let's see if there's questions from the board for Ms. Miller. Further questions?
Thank you, Chairman, for the time. I just want to reiterate that I would appreciate if this came back as an agenda item eventually, no rush, to discuss what does extenuating circumstances mean and what would cause concern, for staff in these cases.
Duly noted. We'll do that. So
Members of the board, initially when this item came before the Department of Taxation, the lack of utilities being run to the lot that was purchased for the initial cultivation was one of the reasons why there was an extenuating circumstance that prompted the move to the La Madre Way location. To this day, I'm not certain that there's power or water that are run to the initial location that was purchased. So at this point, over $4 million have been expended by this licensee in order to just get to this point in stage and build the license forward.
further questions from the board?
I just had one question. Is the cultivation center and the retail center going to be at the same location or two separate locations?
There is no retail location. It's just a cultivation facility. When I said C175, I intended to say recreational, referencing RC175 and C175.
Thank you.
Well, let's try a motion on this item.
One more clarification for me. That again, it's an 8-month extension that they're, Ms. Miller, that you're asking for?
That's correct.
This is Member Young. Then I would move that we approve the extension. For consistency, I'd be more comfortable with granting the 12 months. I don't know if anybody else would like to comment on that. But I would move that in agenda item 8, sorry, let me go down here, 8G, that we move to extend the license for 12 months from February 5th, 2022.
Yeah, I'm in support of that also, to have it consistent with the others in that 1-year time frame. So I could support that. Are there further comments from the board? Do we have a second then?
This is Member Merritt. I second.
Very good. All those in favor signify by saying aye.
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 Any opposed?
Nay.
Record should reflect that Member Drett has voted no. Thank you for your time, Ms. Miller.
Thank you. Good day.
I believe that brings us to items H and I. Mr. Gilbert, you want to take those together?
Yes, thank you, Chair. Agenda item H is for TRNV Key 098 LLC RD 675. TRNV requests an extension of the February 5th, 2022 deadline to March 30th, 2023, or 14 months after the county adopts business license regulations to perfect conditional adult use retail store, RD 675, within the Story County jurisdiction. TRNB submitted another request letter on November 22nd, 2021, with an updated with updated information regarding the situation in Story County. In the updated request, management indicated in August 2021, the Story County Board of County Commissioners allowed adult use retail stores in the Tahoe Reno Industrial Center. Staff want to add that Story County passed on August 17th, 2021, an ordinance amending Story County Code to license cannabis uses permitted by the Nevada Revised Statute by adding Chapter 5.10, Cannabis Establishment Licensing. The ordinance became effective on August 27th, 2021, so a 14-month extension from the date Story County lifted the moratorium is October 27th, 2022. Staff have identified no areas of concerns. And I'll go over to agenda item 8I, which is also for TRNV P098 LLC, RD 671. TRNV requests an extension of the February 5th, 2022 deadline to March 30th, 2023, or 14 months after the county adopts business licensing regulations, whichever is later. Staff obtained a copy of the White Pine County Board of County Commissioner meeting minutes from the October 13th, 2021 meeting, at which the Board of County Commissioners approved amendments to the county ordinances approving marijuana establishments to exist in all areas of White Pine County. CCB staff contacted the clerk of the board in White Pine County, who confirmed White Pine County now allows marijuana establishments to operate in all of White Pine County. Staff have identified no areas of concerns. I'm available for any questions, and my understanding is that Alicia Ashcraft is present and Shane Terry is present via Zoom to give a brief presentation and address any questions you have as well.
Good morning, Chair Nylander, members of the board, Director Klimas. Again, Alicia Ashcraft of the law firm of Armstrong Teasdale on behalf of TRNV. Just to add a little bit to what Mr. Gilbert mentioned with respect to the Story County facility, my understanding from Mr. Terry is that the county commission there just recently voted to implement a 1 mile distance separation restriction, and that effectively has invalidated their identified location. That also makes unavailable the approximate 1.1 stretch of developed commercial space that would be ideal for the development of a facility in Story County. So they're having to look at alternative spots, but that would necessitate offsite improvements and utility connections, which would add further delays and cost. And so with respect to the first item in Story County, Mr. Terry, on behalf of TRNV, is requesting a 14-month extension to April 2023. With respect to the White Pine County facility, that moratorium was just lifted. The company is looking at the zoning laws that have been implemented to determine what would be a location that they could move forward. In both of these instances, it would necessitate a relocation application to the state. And so on the second item as well, TRNV is requesting a 14-month extension to April 2023. I'm available and Mr. Terry is available by way of Zoom to answer any questions the board members may have.
Questions for Ms. Ashcraft or Mr. Terry? Yeah, I'm prepared to go forward, but again, I think we ought to, for consistency reasons, we should make these a 1 year, and then the applicant can come back and just check in with us and we can get an update after a year and see kind of where they're at. Ms. Ashcraft, did you have any concluding remarks?
I don't, Chair Nylander. I understand the need for consistency, so we appreciate that. And we're happy to get whatever the board is willing to to give us on this extension request. Thank you.
Okay, let's try a motion on this, on these two items.
Member Dratt, I move to approve the request for extensions for the deadline to February 5th, 2023 for licensing for to become operational for a TRNVP 098 in Story County and White Lake County, as per agenda item 8H and I.
Do I have a second?
Member Young, I'll second that.
I have a second. All those in favor signify by saying aye. Aye.
Aye.
Aye.
Any opposed? Seeing none. Thank you, Ms. Ashcraft and Mr. Terry.
Thank you so much.
Let's take item J.
Agenda item J is for New Leaf CLV Dispensary LLC D069 and RD069. New Leaf requests an extension of the February 5th, 2022 deadline to perfect provisional medical dispensary license D069 in the city of Las Vegas, and also recreational license RD069. Specifically, a 12-month extension from the date such request is approved. New Leaf reports it has fully completed construction of the dispensary/retail store and was issued its certificate of occupancy on May 29th, 2021. It is yet to open the facility until its transfer of interest is reviewed and approved by the CCB. Staff have identified no areas of concern. I'm available for any questions, and my understanding is that Sean Luce and Jeff Donato are present to give a brief presentation and address any questions you may have as well.
Good morning, Mr. Chairman, members of the board. Jeff Donato with Argentum here on behalf of New Leaf, and with me today is Mr. Sean Luce, the COO. Before I begin, I'd like to apologize in advance. I'm dealing with an upper respiratory issue and on cough syrup and cough medicine, and so I'm going to try to get through this without coughing. We are here today seeking your approval to extend the deadline to become operational for New Leaf CLV Dispensary LLC D069 and RD069. As indicated in our writ request submitted with the CCB, New Leaf has had numerous issues and difficulties to overcome since 2014 when they were initially awarded the provisional certificate, including, without limitation, over 3 years of litigation where the Nevada Supreme Court finally ordered the Nevada Department of Taxation to reissue and reinstate New Leaf's provisional certificate. Obtaining local land use approvals to relocate the establishment to the new property on Las Vegas Boulevard, working closely with the city of Las Vegas during its redevelopment plan of the area around the establishment that impacted the project and caused the redesign of the parking lot and flow of traffic, the moratorium that delayed New Leaf from updating its ownership reflected in its 2014 application, the COVID-19 outbreak that caused construction to be delayed. Despite all these obstacles, however, New Leaf has completed all of its construction and obtained its COO for the establishment in May of 2021. Although construction has been completed, New Leaf can't open the establishment until a TOI application is processed and approved to update the ownership that has caused a change in the initial filing since 2014. And could be updated due to the 3 years of litigation, the TOI application moratorium, and also COVID-19. We anticipated submitting the TOI application to update the ownership with the CCB in the next week. In conjunction with the TOI application to update the ownership, New Leaf will be submitting another TOI application concurrently therewith for New Leaf to merge with Jushi. Once these TOI applications are processed, Jushi will be able to obtain local licenses needed to open the establishment. Since we don't know how long it will take to process the TOI application needed to obtain local licenses, we are respectfully requesting an additional 12-month extension to become operational. And with that, we're here to answer any questions you may have.
Questions for Mr. Donato? I did not have any. Our record is fairly complete on this, and I'm prepared to go forward today.
Member Durrett, I move to approve the request for an extension for 12 months to February 5th, 2023, submitted by applicant New Leaf CLV Dispensary, agenda item 8J.
Is there a second?
Member
It's Member Young,
Merritt,
I'll second.
I second.
Record should reflect that Member Merritt is the second. And all those in favor signify by saying aye.
Aye.
Any opposed? Seeing none, motion carries. Thank you.
We appreciate that and wanted to thank Chief Gilbert for all his work during this process.
Take care of that respiratory thing there. Let's get back to item K.
Agenda item K is for Essence Henderson LLC RD 346. Essence Henderson LLC requesting an extension of the February 5th, 2022 deadline for an additional 12-month period to February 5th, 2023 to perfect its conditional adult use retail store license RD 346 within the city of North Las Vegas. Essence has worked to prepare the required submissions for the city of North Las Vegas, as well as identifying possible locations, preparing standard operating procedures, and ensuring its officers and board members obtain agent cards. Essence's original location was found to not meet the distance separation requirements. Management continues to work with a commercial real estate firm to expedite the process of identifying and evaluating properties, but has found finding a location to be difficult. Staff have identified no areas of concerns. I'm available for any questions, and my understanding is that Amanda Connor and Brendan Bloom are present, and James Leventis is present via Zoom to give a brief presentation and address any questions you may have.
Board. Thank you, Chief Gilbert, for that summary. Just one point of clarification. I think he mentioned James Leventis available via Zoom. That's for a separate agenda item I have in a couple minutes. With me here today on behalf of Essence Henderson LLC is Brendan Bloom. He is the Vice President of Retail Stores for Green Thumb Industries, which is the parent company of Essence Henderson LLC. As of today, they just opened, he oversaw the opening of their 68th retail store. And so he is very familiar with this process. He oversees from retail opening, construct or land identification all the way to the opening of the store through construction. Chief Gilbert identified what has been happening. We kindly request a 12-month extension from the February 5th, 2023 deadline and are available to answer any questions.
Questions from the board? I did not have any questions. This is, we have a full record here, and I think 12 months is probably an appropriate time for this one as well. If there's no questions, we'll go ahead and take a motion on this item.
Member Young, I will motion that we approve item 8K, a 12-month extension from February 5th, 2022 for Essence Henderson.
Very good. Is there a second?
Member Merritt, I second.
We have a second. All those in favor signify by saying aye.
Aye.
Any opposed? Seeing none, the motion carries. Thanks, Ms. Connor, and you're going to stay there with us, right?
Yes, thank you very much.
Mr. Gilbert, let's take items L and M together.
Yes, Chair. Agenda item L is for Nevada Organic Remedies LLC RD 221. Nevada Organic Remedies requests an extension of the February 5th, 2022 deadline. It requests an extension of 12 months to February 5th, 2023 to perfect its conditional adult use retail store license RD 221 within Nye County. In its request, Nevada Organic Remedies reported on its actions to meet each phase of local jurisdiction requirements in its effort to move towards perfecting its license. They have submitted a water utility application, building permit, and an extension of time request for the SUP, and anticipate receipt of all county approvals and plans to open for business in early August of 2022. Agenda item 8M is for Nevada Organic Remedies LLC RD 218. Nevada Organic Remedies requests an extension of February 5th, 2022 deadline. Nevada Organic Remedies requests an extension of 14 months after the city of Henderson lifts its moratorium. CCB staff recently checked with Henderson Business Operations Manager, who confirmed Henderson is in a holding pattern with the co-location requirement until the city council decides to take up the issue at a public meeting. Staff have identified no areas of concern with both of these requests. I'm available for any questions, and my understanding is that Amanda Connor and Brandon Wygand are present to give a brief presentation and address any questions you may have as well.
Thank you, Mr. Gilbert. Ms. Connor?
Thank you, Chairman, members of the board, and Chief Gilbert. Chief Gilbert summarized correctly. I have today with me here Brandon Wygand, Chief Commercial Officer with Nevada Organic Remedies. He can answer any questions you have. We kindly request 12-month extension for RD 221 from the February 5th date to February 5th, 2023. For RD 218, as Chief Gilbert indicated, this is one that is pursuant to the settlement agreement. They should have 14 months from the date the moratorium is lifted. We'd request that extension, but understand if the board wants an update in 12 months. Thank you.
Questions from Ms. Connor? And on these two, I did not have any questions either. I'm prepared to go forward. What's the pleasure of the board?
Member Drat, I move to approve the extension requests for Nevada Organic Remedies under agenda item 8L and 8M.
And in the case of 8L and 8M, it would be for a 12-month period.
12 months, yes, from February 5th, 2022.
Very good. Questions? Is there a second to the motion?
This is Member Young. I will second the 12-month extension.
A second on the floor. All those in favor signify by saying aye. Aye.
Aye. Aye.
Any opposed? None. The motion carries. Thank you, Ms. Connor.
Thank you.
Thank you.
Let's take item N.
Agenda item 8N is for Lone Mountain LLC RD 595. Lone Mountain requests an extension of the February 5th, 2022 for 14 months after White Pine County lifts its moratorium. Lone Mountain provided a copy of the minutes from the October 13th, 2021 White Pine County Board of County Commissioners meeting. The White Pine Board of County Commissioners approved amendments to the chapter 10.62.040A, which changes the zoning requirements of a marijuana establishment from only operating in districts designated industrial park to the ability to operate in all of White Pine County. CCB staff contacted the clerk of the board in White Pine County, who confirmed White Pine County now allows marijuana establishments to operate in all of White Pine County. Staff have identified no areas of concerns. I'm available for any questions, and my understanding is that Derek Connor is present and James Leventis is present by Zoom to give a brief presentation and address any questions you may have as well.
Mr. Connor.
Good morning, Chairman. Amanda Connor, for the record. I am stepping in for my husband on this one, and I have James Leventis here on behalf of Lone Mountain Partners via Zoom to answer any questions. However, Chief Gilbert summarized perfectly this one. White Pine had a moratorium that was very recently lifted. Pursuant to the settlement agreement, they should be given 14 months from the date the moratorium was lifted to have that final inspection, and that is what we are kindly requesting. Thank you.
So it's just for clarification, it sounds like all of the restrictions have been lifted for this jurisdiction?
Chairman, my understanding is that the late October meeting pardon me for, I don't remember the exact date, but late in October of this year, White Pine lifted all restrictions. They would have to go through now identifying a location, appropriate zoning, receiving all approvals, but my understanding is they changed the ordinance at the end of October to allow marijuana establishments, effectively lifting the moratorium.
Okay. Questions from Ms. Connor or Mr. Leventis? I did not have any questions. I'm prepared to go forward. Again, I think I understand what the settlement agreement says, but I still think we'd want to see the applicant back in a year for an update.
My client would not object to coming back in a year for an update.
Great, thank you for that. What's the pleasure of the board?
Member Durrett, for the record, I move to approve the request for an extension to February 5th, 2023, as requested under agenda item 8N.
Is there a second on the motion?
Member Merritt, I second.
We have a motion and a second. All those in favor signify by saying aye. Aye.
Aye.
Any opposed?
Aye.
There's no opposed, so the motion carries. Thank you, Ms.
Thank
Connor.
you.
That takes us to item number 8O.
Agenda item O is for Clear River LLC RD 229. Clear River LLC requests an extension of the February 5th, 2022 deadline, specifically 12 months to perfect its conditional adult use retail store RD 229 within the Henderson jurisdiction. And again, CCB staff checked with Henderson and they are in a holding pattern regarding their co-location requirement. Staff have identified no areas of concerns. I'm available for any questions, and my understanding is that Randy Black and Rusty Graff are present to give a brief presentation and address any questions you may have.
Thank you, Chairman Nylander, members of the board, Rusty Graff, appearing with Mr. Black on behalf of Clear River. I will be very brief. Everybody's familiar with the issues in Henderson. Clear River is intimately familiar with those conditions. They operate an existing Henderson dispensary. They recently applied for and were granted permission to move that facility within Henderson, so they're very familiar with all of the municipalities' conditions and rules regarding the operation of a dispensary in Henderson, and with that, we would submit it.
Question from the board, Mr. Graff? I didn't have any questions on this one. It's straightforward, and we're all familiar with Henderson at this point. But I'm prepared for a motion on this item if there's no more questions.
Member Durrett, for the record, I move to approve an extension as per agenda item 8O, and that extension would be for 12 months, so it would extend to February 5th, 2023.
Is there a second on the motion?
Member Young, I will second that.
We have a second. All those in favor signify by saying aye. Aye.
Aye.
Aye.
Any opposed? Seeing none, the motion carries. Thank you, Mr. Graff. Let's take item P.
Agenda item P is for Wendovera LLC C191, RC191, P126, and RP126. Wendovera requests an extension of the February 5th, 2022 deadline, specifically 18 months after the February 5th deadline to perfect its provisional medical cultivation and production licenses, C191 and P126, and conditional adult use cultivation and production licenses, RC191 and RP126, all within the West Wendover jurisdiction. In its request, Wendovera reported that after identifying its initial location for its cultivation and production license, it had to identify another property. The new parcel will require significant offsite improvements. Their letter of intent for the new site will need to be placed on the West Wendover City Council's agenda and construction plans have had to change after learning the city of West Wendover had ordinance number 2018-01, section 3-10-5C, which prohibits temporary portable structures and requires permanent buildings. Staff have identified no areas of concerns. I'm available for any questions, and my understanding is that Alicia Ashcraft is present and Rebecca Gasca via Zoom to give a brief presentation and address any questions you may have as well.
Good morning, Ms. Ashcraft.
Good morning, barely again, Chair Nylander, members of the board, Alicia Ashcraft, the law firm of Armstrong Teasdale on behalf of the applicant Wendovera. Ms. Gasca is available by way of Zoom. We're happy to answer any questions you have. I would just ask, we received kind of late yesterday a letter of support from Mayor Corona of West Wendover. I did pass that on to Ms. Verkler and Mr. Gilbert. I don't know if it's made its way to the board members. I did bring copies and I'll leave those here as well. I would just highlight a couple things. One, in his letter of support, Mayor Corona did mention, and I'll quote, like many cities in Nevada, West Wendover has long worked to diversify our local economy. The cannabis industry has been and continues to be an integral part of our diversification efforts. Given the pandemic and also understanding the current challenges faced by those in the industry who are trying to develop facilities, it would be unfortunate and certainly not in the public's best interest to see such certificates invalidated due to the conditions created by the pandemic. Again, I hope you've received this letter. I'll leave copies here for staff to distribute. And we have requested 18 months on this extension. The facility does need to be relocated, so we will have to go through a relocation application. And I would just mention, I understand that the board's desire to have consistency may only be inclined to approve 12 months. Again, we'll take whatever we can get, happy to have it. But I would just mention that with respect to these rural licenses and locations, everything is exponentially harder, as highlighted in Mayor Corona's letter, and more costly. So if it is difficult in the urban areas such as Las Vegas or Reno to get something built in a timely manner, it is exponentially more difficult and more costly to do that in these rural areas. But with that, happy to answer any questions and appreciate your consideration of any extension the board's willing to give in this matter.
Ms. Ashcraft, has the applicant found a suitable location at this point to move?
Yes, Chair Nylander, they have identified a location. They're in a letter of intent circumstance with the city. They were just waiting to get this extension to move forward. They didn't want to enter into the lease agreement, move forward with construction and development of the facility and the relocation application if they didn't have more time, because certainly they couldn't get it accomplished by February. Also, as noted in our request letter, we've partnered with a woman-owned minority group for the construction of the facility, and the woman who had the construction know-how and background passed away due to COVID in October, just a couple of months ago. So we've got a couple of challenges. We're trying to kind of regroup in both that situation. Her partner does want to continue with these endeavors. We're very grateful for that. And so with this extension, we'll be able to then move forward with those plans and getting them accomplished.
Great, thank you for that explanation. I did not have any other questions or concerns. Any questions from the board? Seeing none, I think a motion's in order on this item, and we would probably, to be consistent, go with the 12-month period.
Member Direct, for the record, I move to approve the request for an extension under agenda item 8P, request by Wendovera LLC, and that extension would be to February 5th, 2023.
Is there a second on the motion?
This is Member Young. I'll second that.
We have a second.
Member Merritt, I second.
We have a double second. Should cover us. All right, all those in favor of the motion signify by saying aye.
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 Any opposed? Seeing none, the motion carries. Thank you, Ms. Ashcraft.
Thank you so much, Chair Nylander. If I may, this is my last item of this agenda and the last agenda of the year. I just wanted to take a moment to thank the board, Director Klimas, Deputy Director Miles, Deputy Attorney General, and all of the CCB staff for all your efforts and hard work this year. I wish you very happy holidays, a happy new year, and look forward to seeing you next year. Thank you so much.
Thank you and happy
Thank you.
holidays to you as well. All right. I believe that brings us to item number 9, which are the approvals and resolutions. These are items for discussion only.
Thank you, Chair. Agenda item 9, Steve Gilbert for the record. Agenda item 9 is an informational item presented as a notice to the board of establishments that have been issued their final license since the last board meeting. We have 3 licenses to note today. Number 1 is for Essence Tropicana LLC, RD 318. Essence Tropicana applied for an adult use cannabis retail license during the September 2018 application period held by the Nevada Department of Taxation. On December 5th, 2018, Essence was issued a conditional license, RD 318, for an adult use retail store in the city of Reno. On November 8th, 2021, the CCB staff conducted a pre-opening inspection and audit of the facility located at 2881 North Town Lane in Reno. The inspection and audit results revealed the facility was in compliance with NCCR and Title 56 of NRS. The statement of no deficiencies was issued on November 15th, 2021, demonstrating Essence has met the regulatory operational requirements. The CCB agent contacted the City of Reno Business Relations Program Manager, and no issues regarding Essence were disclosed at that time. As a result, final licensure was issued on November 19th, 2021 to Essence Tropicana LLC, adult use retail store, RD 318. Number 2 is for Cheyenne Medical LLC, RD 263. Cheyenne Medical LLC applied for an adult use retail store license during the September 2018 application period held by the Nevada Department of Taxation. On December 5th, 2018, Cheyenne was issued a conditional license, RD 263, for an adult use retail store facility in the city of Las Vegas. On November 23rd, 2021, CCB staff conducted a pre-opening inspection and audit of the facility located at 2975 Sammy Davis Jr. Drive. The inspection and audit results revealed the facility was in compliance with NCCR and Title 56 of NRS. The statement of no deficiencies was issued on November 29th, 2021 by CCB staff and CCB inspection and audit staff indicating Cheyenne met the regulatory operational requirements. The CCB agent contacted Clark County and no issues regarding Cheyenne were disclosed at that time. And as a result, the CCB approved and issued final license to Cheyenne Medical LLC, RD 263, on December 3rd, 2021. Deep Roots Harvest Inc., RD 399. Deep Roots Harvest Inc. applied for an adult use retail store license during the September 2018 application period held by the Nevada Department of Taxation. On December 5th, 2018, Deep Roots was issued a conditional license, RD 399, for an adult use retail store facility in the unincorporated Clark County jurisdiction. On October 25th, CCB staff conducted a pre-opening inspection and audited the facility located at 3725 Blue Diamond Road. The inspection and audit results revealed that the facility was in compliance with NCCR and Title 56 of NRS. The statement of no deficiencies was issued on October 27th, 2021, demonstrating Deep Roots has met the regulatory operational requirements. The CCB agent contacted Clark County and no issues regarding deep roots were disclosed at that time. As a result, final licensure was issued on November 12th, 2021 to Deep Roots Adult Use Retail Store Facility ID RD 399. With that, Chair, members of the board, I'm happy to answer any questions.
Thank you, Mr. Gilbert. Yeah, these are pretty straightforward. We've got the final inspections and the records, and I didn't have any questions. Any questions for Mr. Gilbert?
No questions.
Seeing none, thank you, Mr. Gilbert. And that brings us to the briefing from our executive director, Mr. Calamis.
Thank you, Chair. And I know we have another item to get to, so to everyone's shock, I will be actually brief and just say we have a workshop today at 1 o'clock. We may push that back a little bit depending on how long this meeting goes, but that is going to be the first workshop on consumption lounges. So I wanted to put that on the radar. And then second, a little bit of housekeeping. There were some inconsistencies that staff found during some of the reviews on licenses for payments, specifically renewal payments for conditional licenses. Some licenses of conditional status would get billed for renewal payments. Others, mainly from the 2018 round, were not. This was under the prior oversight body. So it's a heads up to some licensees. We'll be getting some letters in the mail just to bring them up to speed and up into compliance on the renewal payments. It is not obviously any fault of the licensees, but I wanted to give a heads up that those are coming. If you've got questions when you receive it, please reach out to licensing and Chief Gilbert. So with that, Chair, that's all I have, unless you have any other questions, and I'll turn it back to you.
Questions for Executive Director? Seeing none, I'll just note for the record that our next board meeting is slated for January 25th. So please mark your calendars for that. And with respect to future agenda items, I will, and Mr. Klimas, if you could make sure that we follow up with Member Durrett on, her concerns about the extensions and sort of that process of how we might make that a little more efficient. That I would appreciate that. Okay, now we trailed 2 items from this morning, and we'll see if are those representatives present? It's BBMC.
Mr. Chairman, members of the board, David Staley, Chief of Investigations for the CCB. Items number 4E and 4F are the TOI applications for BB Marketing LLC for BB Marketing, BBMC LLC for BBMC, and Interreserve Enterprises Interreserve. TOIs number 19037A and 19037 were filed for approval of buyouts of minority shareholders in preparation of the proposed acquisition of BB Marketing's membership interest in BBMC by Interreserve. TOI number 19076 was filed requesting approval for a proposed acquisition of BB Marketing's membership interest in BB Marketing's membership interest by Interreserve. Both BBMC and Interreserve have requested withdrawals of TOI 19076 as the proposed acquisition has been terminated. In addition, BBMC has requested a waiver pursuant to NCCR 5.125 of the requirements of NCCR 5.110 regarding the need for minority owners to have a valid agent card. BBMC has adequately addressed the items required in NCCR 5.25 to allow the board to approve such waiver. Staff suggests that if approved, the board limit BBMC's 5.125 waiver to expire on such agenda date as BBMC's next TOI application is heard. Staff identified areas of concern with TOIs 19037A, 19037, and 19076 regarding BB Marketing, BBMC, and Interreserve. These areas of concerns are broken down by entity as follows. It appears that BBMC has completed the proposed minority buyouts requested in TOIs 19037A and 19037. Review of various documents, including BB marketing tax returns, indicates that the membership of BB marketing and BBMC matches the after description included in the TOI applications. In addition, staff has made numerous requests for financial and other documents from BB marketing and BBMCs, but the companies have not submitted the requested information. In addition, on December 8th, 2021, BBMC sent the CCB a letter requesting approval to temporarily suspend its operations due to financial hardship. In addition, as you are aware, on October 10th, 2019, a federal indictment was issued by the United States District Court for the Southern District of New York. The indictment described a failed attempt by foreign nationals to acquire Nevada retail cannabis license by donating money to Nevada political campaigns. The indictment charged Lev Parnas, Igor Fruman, David Correa, and Andrei Kukushkin of making illegal campaign contributions with funds provided by an unidentified foreign national. Fruman and Correa pled guilty to the charges, and Parnas and Kukushkin were found guilty in a jury trial ending on October 27, 2021. On September 21st, 2021, leading up to the Parnas-Kukushkin trial, the United States Attorney for the Southern District of New York identified foreign national number one as an Andrei Maria. In addition, CCB staff have reviewed numerous documents indicating that Maria was heavily involved with Kukushkin, now a convicted felon, in various operations in other regulated United States cannabis markets. This information was identified as an area of concern because Maria is the sole owner of InterReserve, who has applied to acquire controlling interest of Nevada licensed BBMC. CCB has also identified an area of concern regarding an October 16, 2019 sale of 36,469,620 shares of another licensee, Pure Leaf Holdings Inc., by Muriev and Muriev related companies without receiving prior approval by the Nevada Department of Taxation. An additional area of concern was identified because Muriev related companies have loaned or contributed approximately $13 million to BB Marketing and BBMC to fund the buyout of the BBMC minority shareholders and the build out and operations of BBMC. Even if the requested withdrawal is approved, it appears that Muriev may be able to exert influence over BBMC due to the outstanding $13 million in loans and contributions. Finally, Muriev does not have the required agent card application on file as a prospective owner. Muriev's agent card application expired on February 19, 2020. CCB staff have provided potential options for the board's consideration to proceed with TOIs 19037A, 19037, and 19076, and have explained those options to BBMC and InterReserve Council. I am available for any questions, and my understanding is that Derek Connor, Jared Kahn, and Robert Frey are appearing for BB Marketing and BBMC, and Margaret McCletchie and Stephen Len are present representing InterReserve, and Andre Muriev. Andre Muriev was noticed that he was required to appear for this item, but is not in attendance. With that, Chair Nylander, I will turn this item back to you.
Thank you, Mr. Staley. Before we move on, let's see if there's questions from the board for Mr. Staley.
None for me.
Okay, thank you. Could we have council approach and note their appearances for the record?
Sorry, I took up the whole table. Derek Connor appearing on behalf of BBMC.
Good morning, Chairman and members of the board. Jared Kahn on behalf of BBMC, BB Marketing, and Robert and Michael Fry.
And for the record, I'm Maggie McCletchie. I'm here with Mr. Stephen Len. Just to be clear, we represent InterReserve, which is 100% owned by Mr. Muriev, but we do not represent Mr. Muriev personally in any matter.
Good morning or afternoon, I guess. It's Steve Wen. I'm here on behalf of InterReserve.
Mr. Connor, it looks like there have been transfers of interest that occurred without approval. What's the position of your client on that?
Our position is that, similar with other licensees, that, when there's been money that's exchanged hands while we're waiting for these transfers, I don't know if that necessarily in and of itself constitutes an unofficial, unapproved transfer of interest, just because money has been given out. In this case, it sounds like, this was submitted quite some time ago. I believe this was submitted under at least the Department of Taxation. While I understand the law as it was at that time, the processes were in fact different. The way these things were dealt with under DPPH was different than they were under the DOT, and now under the way that we deal with them here with the CCB. And I think consideration should be given to that and for the amount of time that has transpired since these transfers were submitted. I believe with with respect to 9073A and 9037, this is really just to transfer out about 7 minority members, each of which who held a relatively small percentage of interest in the companies. These individuals no longer desire to be a part of the cannabis industry. We would request that at least those transfers be processed, and we are happy to enter into discussions with the department or the deputy AG rather, like the other licensees have been offered prior to this hearing today and on prior matters. With respect to the additional areas of concern, we did provide a lot, and I do want to thank Mr. Staley and also Mr. Justice, who's sitting back here, the investigators that were a part of this case. We've worked very closely with them for a long time on this, and I know it's been very, very difficult for all of us. We did turn over a lot of financials. This binder represents, the majority of the financials, I believe, that were submitted to Mr. Staley. One of the things we turned over was a general ledger, which my understanding constitutes basically every dollar that came in or out of the company. There were certain things that we just didn't have, profit and loss statements and that sort of thing that just weren't available to us because those companies were effectively non-operation and didn't have profits or losses to show. With respect to the records that we are required to keep, I would turn your attention to, NCCR 6.075, which states that business records, that we are to develop a plan to maintain policies and procedures regarding, if you go to subsection 1B, business records. Well, I mean, that's kind of vague. I don't think there's a listed requirement of what we absolutely must have. This is sort of a list of things that we should or could have. In this instance, there were certain things that we just did not have to provide, and we couldn't create them out of whole cloth. With respect to the area of concern regarding the company temporarily shutting down, that's the reality of the situation. The company is out of money. It needed to suspend operations pursuant to the rules, so that's what we did. The power was being shut off by the landlord, so therefore we had to shut down. We hope to get operational again once a financial plan is put in place that will allow us to do that. Beyond that, I am happy to answer any questions or turn it over to counsel if the board has questions for the other attorneys.
Questions from Mr. Connor? The letter you submitted, which basically is a closure. So did you, I guess you're just notifying the board that the facility was going to close?
Yes, when we lost power and we were required to shut down when you lose power, because you lose power to things like cameras. And to be clear, there is no product in the facility. It is completely empty. It's just when you lose power, you have to shut down. So we have chosen to temporarily suspend operations until a plan is put in place to operational again.
Okay, further questions on that portion of the application?
Member Durrett, for the record, I have a question about what would you consider going through with a transfer if it wouldn't be money? And I was wondering if the AG could also answer that question, if they think that falls under the definition of a transfer.
Well, there's other regulations that also indicate if there's sufficient control
over a licensee, then that entity or person would have to obtain a cannabis license as well.
Understood. I would also, drawing our attention to 5.110 again, it's ironic. There's actually a logical fallacy in subsection 1. It says a transfer of ownership cannot occur until it's been approved by the board. That being the case, those two things cannot exist in time. You can't have an unapproved transfer if all transfers have to be approved by you. That's just food for thought for when we clean these language up later on. With regard to the control aspect, that's also, I don't think, very well defined in the regs. What is control? Is Mr. Murayev a voting member of BBMC? No. I owe the bank a lot of money on my house. That doesn't mean they can show up and paint it. Same thing with my truck. They can't change my tires just because I have a note out on it. But because Mr. Murayev owes us money, I don't believe that actually establishes legal control over the company under any terms that I've seen in the regs. Or we owe him money, sorry.
Mr. Chairman, if I may, we reached our conclusion that a transfer of interest had occurred in regards to the minority shareholders by reviewing all of the tax returns that BB Marketing, BBMC have filed over the last 4 years. And in those cases, they indicate their the membership of the partnership interests. In all those cases, they indicated that those TOIs had occurred and reflected that none of the individuals that had been bought out were present on any of those tax returns that's receiving percentage of revenue from the operations of those companies, and in fact represented the percentages owned by the individuals, reflecting the after component of the TOIs that were submitted with the Department of Taxation.
And I understand, and Mr. Staley, he is correct. They filed the tax returns as if the transfer had been completed. We're not denying that, and that would be one of the things that we would be happy to discuss with Deputy AG afterwards, if this were to be approved today, for at least the two underlying transfers. As Mr. Staley noted, the final transfer that would have involved Mr. Murayev has been requested to be withdrawn by Interreserve itself, and by we essentially consented to it on behalf of BBMC. Do you have anything?
Mr. Chairman and the board, just a real quick clarification on the minority transfers. At the time when those minority members were looking to have their shares sold, they would withhold signing the appropriate documentation unless they received payment. And so at the time, there was a waiting process, as we all know, for change of ownerships. But if we could not buy them out by actually remitting payment at that time, it would not have occurred based on their negotiating tactic. So I think that just kind of addresses Ms. Durrett's question about whether that is a change of ownership, because the money transfers at that point, we still then submitted the paperwork appropriately to the department at the time for that. But just because the payment was made at the time was also just arose out of the way that deal was structured with those minority members. Otherwise, they would have withheld if they had to wait 18 months, for instance. So, thank you.
I have some questions on the request to withdraw. So I guess what argument would you make that the board should allow Mr. Murayev to withdraw, given what Mr. Staley has indicated, that he clearly was associated with individuals who pled guilty and were indicted to campaign finance provisions? He is a lender, is my take on this, even if he doesn't have an interest. So why would the board be inclined to grant that withdrawal?
I do not represent Interreserve or Mr. Murayev individually, so I will stand aside and allow Miss Maggie McCletchie respond to that, if that's okay.
For the record, Maggie McCletchie for Interreserve. If I may, I just want to provide a brief background of what has gone on here. Interreserve has provided Mr. Fry and the various cannabis entities he controls over $13 million. The relationship between the target companies and InterReserve, unrelated with the immediate concerns about Mr. Muriev, have disintegrated over the last few years. Mr. Len and I only relatively recently came to represent InterReserve over the last few years, and we have both, just to be clear, have endeavored to protect our client, including by ensuring compliance. While Connor and Connor prepared and submitted the initial transfer application as counsel for BBMC, I've advised InterReserve since late 2019, specifically on various compliance matters with regard to the business side of the transaction in which the Fry entities are represented by Mr. Khan, including advice aimed at ensuring that neither Mr. Muriev nor InterReserve ever improperly assumed or had operational or other control of any cannabis establishment in Nevada, unless and until the state approved the proposed transfer. Recently, as Mr. Staley mentioned, InterReserve decided not to proceed with the transaction that would have made an owner of BBMC, which holds the cultivation and production licenses. There were some separate issues between the parties with regard to a dispensary license, which has since been withdrawn unilaterally by the Fry entities and sold to other entities. But if InterReserve did not withdraw the transfer request, and if the CCB approved it, the transfer, then and only then would Muriev, through InterReserve, through BMC, have any ownership interest. The purchase and sale agreement memorialized an earlier agreement between the parties. These documents were all drafted before Mr. Lenz and my involvement, but the purchase and sale agreement specifically give InterReserve the absolute right to terminate contractually, to terminate the transaction before closing. The concerns, it's my view and my client's view that withdrawing the request to become an owner addresses the concerns about Mr. Muriev being an owner. There are obviously serious ongoing concerns that my client has, including the fact that almost none of the funds have been returned to InterReserve. Frankly, the Fry entities have expressed an inability and an unwillingness to make reasonable efforts to unwind this transaction. We've endeavored to try to work with them on discussions on doing so in a compliant manner, other than some escrow funds that were ultimately provided after initial resistance and a request by BMC to use those funds for operational needs. Our concerns with this board approving the other transfers from the minority owners to the other owners, including Mr. Fry, are that those funds that were used to buy out the individual owners did not come from Mr. Fry. They came from my client, and the concern is that the Fry entities are both unwilling to unwind this in a compliant manner, but yet want the benefit of the transaction and want to still proceed with the other transfer that was funded by InterReserve. My client, in more direct response to your question, Chairman Nylander, my client understands and respects the authority of the CCB, as do I, with regard to suitability determinations for proposed owners. My client absolutely understands that no transfer can ever be effectuated without CCB approval. I mentioned my efforts and Mr. Len's efforts earlier to ensure that there were no compliance issues, and we've advised my client, and my client followed our advice to never assume any operational control of the company. However, it's my client's position that the statutes governing the Cannabis Compliance Board, while they provide that the Cannabis Compliance Board can come up with regulations and is responsible for approving owners and is responsible for approving transfers, there's nothing in the statutes actually that requires CCB approval for a withdrawal of a transfer or a termination of a contract. And that's essentially what we have here. My client contractually from a February 2019 contract had the right to terminate this transaction for any reason. It's my view that the CCB can't force a party to go forward with a transfer application, a request to become an owner when contractually it has the right to terminate the deal before closing, which my client had. It had a unilateral absolute right to terminate the transaction for any reason. And again, that was from February of 2019. Again, it's also my view that that to the extent there are concerns about Mr. Muriev as expressed by Mr. Staley, and as discussed by the board, the withdrawal addresses those concerns. Mr. Muriev will not be an owner, but I'd like to walk through each of the concerns that Mr. Staley has expressed today. And I do want to thank both Mr. Staley and Mr. Justice. Mr. Staley and I have worked together on a few complicated matters. I always appreciate, even when we disagree, I always appreciate working with Mr. Staley. It's always an intellectual exercise, and he's very professional, and I appreciate it. Again, Mr. Len and I don't personally represent Mr. Muriev. However, it's my understanding that Mr. Muriev has never been charged, let alone convicted of any crime. Further, it's my understanding the state of Nevada did previously issue Mr. Muriev a temporary agent card reflecting what I just said, that he's never been convicted of any crime. He's also, it's my understanding that he's never been charged with any crime. He was named as a person of interest. Mr. Staley mentioned that. And again, if this transfer is withdrawn and we're not allowed to proceed, then Mr. Muriev will not be owner of the entity. With regard to CCB compliance, I want to just tell the board that even after my client informed CCB and the target BBMC that it wanted to withdraw this transfer and it did not want to go forward any further, my client has endeavored to cooperate. It spent significant resources on providing as much information as possible to Mr. Staley. We've provided, I don't have the binders here with me, but we have also provided significant information to address a number of questions and concerns that Mr. Staley and Mr. Justice raised. With regard to the agent card, handling the transfer was previously, was not just previously, but the transfer was handled by Connor and Connor, but it's my understanding, so it's only recently that I learned that his temporary agent card had expired, but Mr. Muriev, from his point of view, no longer wishes to be an owner of a cannabis establishment. So clearly, to me, it's not necessary for him to have updated his agent card application because he didn't want to be an owner. I don't see anything in the statutes or regulations requiring a proposed owner to maintain a current agent card. That's for existing owners and for employees and persons working at cannabis establishments. It's not for proposed owners. It is absolutely true that you cannot become a proposed owner unless you pass a suitability background check and unless you get an agent card. Here, Mr. Muriev does not want to proceed with being an owner, so I don't think he needs to do an agent card application. With regard to the Curaleaf transaction, my information is limited because I don't represent Curaleaf and I don't represent Mr. Muriev personally or in connection with that transaction. We did by letter apologize on behalf of InterReserve and Mr. Muriev for that issue. It's my understanding that the board has already addressed the unauthorized transfer via Curaleaf. And I'll just point out that it's to take Mr. Muriev out of Curaleaf, and I believe that his shares were transferred to another existing owner of Curaleaf who had previously been approved by the CCB. With regard to the loans, InterReserve is also concerned about the loans. We have been trying to engage in discussions. We do want to resolve those in a compliant manner. As I mentioned, Mr. Len and I have extensively advised InterReserve over the past few years to not have any role in operations, not to exert control in the cannabis entities as a prospective owner. Now that InterReserve is not a prospective owner, we would clearly provide the same advice, and our client would continue to follow that same direction. We will be holders of those. We do. BBMC will owe our client significant amounts of money, over $13 million, and there's some unrelated to this, but there's some unrelated to these specific licenses or some other issues with regard to a dispensary sale that need to be addressed with BBMC as well. So there are significant funds that BBMC owes InterReserve We have and hope to continue to have discussions with BBMC about trying to figure out a way to move forward and disentangle the parties as quickly as possible, frankly. Obviously, my client is not in a position to just forego those the monies owed, but it certainly will not exert control. Mr. Len and I would not allow our client to exert control, and I certainly don't think that BBMC and Mr. Connor would allow my client to exert control simply because they are owed significant funds by the BBMC. I don't know, Mr. Len, do you have anything further?
Yeah, the only thing I would add is that the February 19th agreement specifically contemplates unraveling the transaction if CCB or DOT at the time approval was not obtained by a date certain. So there was a clear understanding reflected in the agreements that the approval was required.
Did you have any other remarks, Ms. Gletchy?
I do not, unless there's any other questions.
Well, I'll open up to the board here in just a minute, but let me circle back on this withdrawal notion. So there is a regulation which specifically, my reading of it is that it sets up a mechanism where the board, in acting upon an application, can either grant or deny the withdrawal request with or without prejudice. And I guess I'd ask our Attorney General's office if how they're reading this thing as far as a withdrawal.
Thank you, Member Nylander. And my opinion is you are correct. Under NRS 678B.380 subsection 2, the board is charged with adopting regulations that prescribe the procedures and requirements for a transfer of a license to another party. And under NCCR 1.058, an application is defined to include anything for which board approval is required. So of course, we do treat the transfer of interest request, which require board approval, as applications. Under NCCR 5.000 subsection 4, a request for a withdrawal of an application, which in this case would be the TOI application, may be made at any time prior to final action by filing a written request to withdraw with the board, which was done recently here. And I'll note that the expiration of the aging card was at least a year prior to this request for withdrawal of the application. And subsection 4 does specifically indicate the board may, in its discretion, deny the request for withdrawal or grant the request for withdrawal with or without prejudice. If the withdrawal is granted with prejudice, the applicant is not eligible to apply again for approval for another year. So that is the way we do read the statute on this end. And I would note that we applied these regulations and statutes the very same way earlier today when Mr. Hardy made an application or requested to withdraw his application for approval as a receiver. You voted on that just the same way as you would vote on this withdrawal as well.
Okay, well, thank you for that, Mr. Rath. I mean, in the few years I've been sitting here, we've done several of these. And that's my reading of the regulation also, is it really applies anytime there's an application that's been filed by an applicant. So, but let me see if there's other questions from the board at this time.
Member Durrett, for the record, I have a quick question. So Mr. Muriev was advised to be here today and he's not. Do we know anything about that?
Yes, ma'am. Member Durrett, he noticed Andre Muriev to appear in, I don't know the exact date, outside of the requirements to provide notification of the public meeting. And a formal request to appear was sent to his attention at the time.
That is correct.
Further questions from the board? Seeing none, I'll bring this back, unless there's concluding remarks from the applicant, I'll bring the matter back to the board.
Chairman Nylander, Jared Kahn for the record. I just wanted to respond to a couple statements that were made here today. On behalf of the licensee, we have been in earnest trying to resolve this situation. This has actually been a discussion for almost 2 years in trying to resolve it, simply because when this matter came to our attention, we requested in a reserve and their counsel to withdraw the application long ago. Ms. McCletchy had indicated that she was confident her client would be approved and to continue moving forward with the transfer of interest. The licensee attempted to stop this transfer. We would have had to have still resolved the debts, etc. But the licensee has taken steps to try and address this. Now, today, where we stand, we are unable to resolve how to settle those debts, although we are trying. There are other complicating factors when we're trying to settle the alleged $13 million in loans to what are BBMC and BB Marketing. When an entity is not operational, it's difficult. So although Ms. McCletchy says we're unwilling to, we are willing to, but there is within reasonable and commercial reasonable standards of how to resolve things when a business is not operational. So I just want to make sure that's clarified on the record. Thank you.
No, thank you for that too. And I don't think, at least I'm not suggesting that there's any bad faith going on. I recognize you guys are trying to figure out the best way to unwind this. But as a board, to me, doesn't seem like it's ripe for action today. There's so many things that are moving parts going on right now, plus the place is closed. And with respect to Mirav, we have jurisdiction over him by virtue of him filing those applications. Mm-hmm. And in my view, he's a lender still, and at the very least, he's a creditor. And it's part of our responsibility to know exactly where the funds go. We follow the money. And in this case, the funds came from an individual who we know associated with some other individuals who committed some very serious crimes. So I'm not of a mindset to let him out of our jurisdiction because he's still a lender and a creditor. And I would like to pull this back to staff so we can do further investigation, keep monitoring it, and maybe resolve this issue that's still ongoing about whether a transfer did in fact occur or not. And I don't see that there's any prejudice to the licensee because the place is closed. But I'm open to whatever suggestions the other board members have. That's just kind of where I'm at.
I would agree.
May I briefly be heard? This is Maggie McCletchy for the record. I just want to make clear that I'm not agreeing with Mr. Khan's representations of what I said, and that Mr. Khan and I have some different recollections of what has transpired. There's obviously some complicated issues here, including the fact, frankly, that Mr. Khan is potentially a beneficiary of some of these funds historically. So there's some complicated issues here, and I just want to make clear that I'm sure Mr. Khan doesn't agree with my recitation of some of the facts, and I do not agree with his recitation of what I have said and represented.
Okay, thank you for that. So I'll bring it back to the board. What's the pleasure of the board?
This is Member Young. I agree that I think there's a lot of issues that are not very clear here. And I would recommend, I don't know if this would be a motion, that we turn this back over to the staff for further investigation. And this is not clear to me at all. And it sounds between the opposing counseling parties that they're also clearly not in agreement. So I don't think we should take action on this today.
Thank you, Dr. Young. Member Merritt?
Yes, I agree also.
Okay.
Yeah, more clarity is needed.
And Member Durrett?
I agree, and I think it would be great if Mr. Muriev appeared when it comes back on the agenda.
Okay, let me ask Mr. Rath, do we need a motion to refer this back to staff today?
I think you could do a motion to refer it back to staff.
Okay, it's probably safest to do it that way. Why don't we go ahead and I'll accept a motion to refer this item back to the staff for further consideration.
Sorry, this is Derek Connor for the record. I believe there was an additional, there were the 5.125 and the other waivers that we had pending. And I thought Mr. Staley recommended those be approved, irrespective of the areas of concern that he raised with regards to the transfers of ownership. I would also like to add that there is some prejudice to my client if the underlying minority membership transfers are not approved. They're still having to chase those people down because we don't have the 5.125 waivers approved for agent cards. We might have to chase them down for money. We're still incurring time and effort involved with those pending transfers. So there is still prejudice to my client if you want to consider having them to chase down other owners and spending money to continue this transfer. I believe that should at least be mentioned on the record.
Yeah, and my concern is just this thing's all intertwined together. And I have some concern that if we prove something now, it's not going to be what we think it is right now.
And I understand your concerns. I appreciate that.
And your comments are duly noted. I know it's hard to unwind things when you have the minority interest holders who want out, but there's no money. I mean, it's a difficult spot. But for now, I'd be more inclined to support just referring the whole thing back. There's much work that needs to be done on this. And I'm afraid to take a piecemeal approach to it right now. But, well, let's see if we can, who'd like to make a motion to refer it back to staff or refer parts of it back to staff if that's what you would like to do.
Member Dredd, I move to refer agenda items 4E and F back to staff for further discussion on and maybe a further breakdown of all the different parts involved and maybe also specifically addressing the request for withdrawal and the support that is actually necessary and that it can't be done unilaterally without board support.
Very good. We have a motion on the floor. Is there a second?
This is Member Young, I second that.
We have a second. Further questions or comments on the motion? Seeing none, all those in favor signify by saying aye.
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 Any opposed? Seeing none. Thank you for your appearances. And I understand it's a difficult situation. It's given me a giant headache. I need an aspirin right now. But happy holidays to you all.
I think we all agree about that. Thank you.
Yes, thank you all.
Happy holidays to you.
See you next year.
I believe, Mr. Cannabis, that brings us to, I believe that closes our business except for public comment. Is that correct?
That is correct.
Okay, let's go ahead and open it up for public comment.
Chair, I do not see any public comment here in Las Vegas.
Okay, let's check in with Carson City.
Hello.
Good afternoon.
Good afternoon, Chair. Today, I'm Will Adler representing White Pine County extremely briefly right now. I just want to clarify that, yes, on October 13th, they did pass Ordinance 523 that did change the cannabis ordinances in their whole county. In addition to that, they would like to thank the CCB for promulgating these regulations this afternoon. That will be opening up the new application process that hopefully will allow them to have new cannabis businesses in their county. I'll save the rest of my comments for later this afternoon. Thank you.
Great, thank you, Mr. Adler. And does that conclude the public comment section? Did we get it in writing, Mr. Calamus?
I believe we did receive some before the meeting. They will be posted online. If we received any during the meeting, they will also be posted online.
Okay, and I know I did see one that came in for the workshop, but that was not addressed for our meeting today. Very good. Is there anything else the board members want to raise? Seeing none, we are adjourned. Thank you,
Happy
everyone, and
holidays.
happy holidays to you.
Happy holidays.